At this time, the court calls State of Wisconsin versus Stephen Avery, case number 05CF381. We're here this morning on a motion hearing as part of the continuation of the trial in this matter. Will the parties state their appearances for the record, please?
Good morning, Your Honor. May it please the court, the state appears by Assistant Attorney General Tom Fallon, Assistant District Attorney Norm Gahn, and District Attorney Ken Kratz, the special prosecutors for the state of Wisconsin.
Good morning. Stephen Avery is in person, Jerome Buting and Dean Strang on his behalf.
In terms of agenda today, it's the court's understanding we're going to begin by hearing the state's motion to admit EDTA test results. Both parties agree that the state will make its offer of proof on the record today. The court will then hear oral argument and make a determination as to whether or not the state's preferred evidence is admissible. Should the court determine that the evidence is admissible, the court will then hear the defendant's motion for sequential independent testing and funding, and there's also a motion that was filed or made orally by the defence during trial, in which the defence renewed its fair testing motion, and the court will hear oral argument on that at the end of the day today. Time permitting. Counsel, is that your understanding of our agenda?
Yes, Your Honor.
All right. The state may call its witness.
The state would call Dr. MARC LEBEAU.
Please raise your right hand. Please be seated. Please state your name and spell your last name for the record.
My name is MARC, M-A-R-C, LEBEAU, L-E-B-E-A-U.
What is your occupation?
I'm the unit chief of the chemistry unit at the FBI laboratory.
And where is your laboratory located?
It's located in Quantico, Virginia.
And how long have you been employed at the laboratory?
Since 1994.
And how long have you been with the unit chief of the chemistry unit?
Since September of 2000.
And what are your duties within the FBI laboratory?
I manage the day-to-day operation of the unit, overseeing not only the cases that come into our unit for analysis, but also review the results of the scientists that work under me to ensure that all of the requirements are in place before the reports are released to our contributors.
And what is your educational background, please?
I have a bachelor's degree in chemistry and criminal justice from Central Missouri State University in Warrensburg, Missouri. I have a master's degree in forensic science from the University of New Haven in West Haven, Connecticut. And I have a doctorate in toxicology from the University of Maryland in Baltimore.
And doctor, would you please describe any experience and special training that you have in your field?
Well, when I started with the FBI laboratory, I was thoroughly trained in the relevant areas of forensic chemistry and forensic toxicology, as it pertains to the types of examinations that we're typically asked to perform in our laboratory. I worked for 4 years before I started with the FBI laboratory. I worked as a laboratory supervisor at the medical examiner office in St. Louis, Missouri. Before that, I was a chemistry instructor for the University of New Haven. I worked as a laboratory intern for a private toxicology laboratory, and I have also worked as a laboratory technician for Monsanto Chemical Company in St. Louis, Missouri.
Do you belong to any professional or scientific organizations in your field?
Yes, I do.
And what are they, please?
I am an active member of the Society of Forensic Toxicologists, in which I serve on the board of directors in the organization, and also chair one of the professional committees. Likewise, I'm a member of the International Association of Forensic Toxicologists, and again, I'm on 2 committees in that organization. I'm also an active member of the American Academy of Forensic Scientists.
Do you attend conferences within your field?
Yes, I do.
And are you ever asked to present or speak at the conferences in your field?
Yes, I am, quite frequently.
Could you describe some of those for His Honor?
I'm asked quite often to be a speaker in a number of workshops for these different organizations, and I'm also often invited to lecture in areas of forensic toxicology, specifically with drug-facilitated crimes. I often get invitations for that.
Would you explain a little bit of what you mean by drug-facilitated crime?
Yes. These are crimes in which, as the name implies, the crime itself is helped out by the fact that an individual has slipped a drug, and the drug usually incapacitates an individual so that crime can occur.
Is the FBI laboratory accredited?
Yes, it is.
What does it mean? What does that mean to be accredited?
It's that an outside expert body will come into your laboratory and inspect its practices to ensure that it's following the standards that have been set up by that outside body.
And do you undergo proficiency testing at the FBI?
Yes, we do.
And do you yourself undergo proficiency testing?
Yes, I do.
And have you passed all of your proficiency tests?
Yes, I have.
Have you ever testified as an expert before?
Yes, I have.
And how many times?
I don't keep track of these numbers, but it's roughly 40 to 50 times I have testified.
Have you ever been rejected as an expert in your field?
No, I have not.
Have you ever authored or co-authored any peer-reviewed journals or articles?
Yes, I have.
And could you explain some of those to the court?
I have authored and co-authored approximately 20 scientific articles for chapters in books. These have ranged in various areas of forensic chemistry and forensic toxicology.
Have any of these articles dealt with the use of a technique called LCMS-MS?
Yes, they have.
And could you describe for the court some of the articles that you have co-authored, or perhaps if there are any textbooks that you have been involved in?
Yes, I have authored an article that analyzes for a drug called rufinol using LCMS-MS techniques. I have co-authored an article that talks about a drug called mivacurium, also using LCMS-MS techniques.
Could you just spell, when you get to the names of drugs like that, could you just spell them, please?
Yes. Rohypnol is ROHYPNOL. Mivacurium is MIVACURIUM. And then additionally, I co-authored an article on another drug that's called doxycurium, DOXACURIUM. And again, that's using LCMS-MS techniques. I recently was an invited guest reviewer for a textbook on the topic of LCMS and LCMS-MS techniques. And then I have also co-edited a book on a drug-facilitated sexual assault that involved within the chapters the topic of LCMS and LCMS-MS techniques.
And when you talk about the LCMS-MS techniques, is that the technique that you used in the analysis in this case?
Yes, it is.
Would you describe how your lab became involved in this case?
Well, I received a phone call from the district attorney's office asking if we had a method that would allow us to determine if EDTA was present in bloodstain or not. Through the course of the conversation, we were asked if we would be willing to work with this case for the state, and we agreed to do the work on this case.
And were you informed of the nature of this case? Basically, that there were accusations of planting by law enforcement officers of evidence?
Yes, I was.
And why would the FBI be concerned about a case that involves allegations of planting evidence by law enforcement officials?
Well, one of the many types of cases that the FBI investigates are corruption by public officials. So it's one of the areas we consider to be a very serious accusation for two reasons. If there's a crooked public official out there, we want to make sure they get off the streets. And likewise, if an innocent public official is being wrongfully accused of something, we want to at least try to set the record straight to ensure the public's trust in that organization or that individual.
Before we go any further, Doctor, I have marked that exhibit as 433. Is that correct?
Yes.
Could you please describe what that exhibit is?
This is a copy of my curriculum vitae describing my experiences, my education, etc.
And does that basically summarize what you testified today about your qualifications?
Yes, it does.
Now, if you were sent samples to test in this case. Is that correct?
Yes, I was.
And could you tell the court what it was that was sent to you?
We received a number of different items. They were swabs collected from a vehicle, a Toyota RAV4, as well as control swabs and a tube of blood from Stephen Avery.
And what type of instrument did you use in testing these items?
We used the LC-MS instrument.
And could you describe for the jury just exactly what this instrument is and what it tests for?
Well, the LC-MS instrument is actually 3 different instruments that are linked together. The LC stands for liquid chromatograph. And what this does, it allows us to take a mixture of chemicals and separate them into individual components so that they are presented to the mass spec portion, the MS portion, individually. So a good example of this would be if you had a sack full of marbles, if you will, and you had small marbles, medium-sized marbles, and large marbles. And if you even complicate it more and suggest that the large marbles were both red, some were red and some were blue. If you would pass the marbles, simplifying it, through this instrument, it would separate them so that initially the small marbles would come out, then maybe a minute later the medium-sized marbles, and then a minute later maybe the large blue marbles, and then 30 seconds after that the red large marbles. So it allows those to be separated and then introduced to the next instrument, which is your mass spectrometer. The mass spectrometer is an instrument that gives you detailed information about the weight of the chemical that it's analyzing, as well as it applies energy to fragment the chemical into many pieces that presents a very consistent fragmentation pattern that forms what we call a chemical fingerprint, if you will. It allows us to then search against databases for what chemicals give you what particular fingerprint and make the vocal identification of the actual chemical. By linking 2 mass spectrometers together, you're able to do very complex and sophisticated experiments that improves the specificity and selectivity of the analytical procedure.
And is this instrument something that is used in the field of analytical chemistry?
Yes, it is.
Would you explain to His Honor exactly what the field of analytical chemistry is?
Analytical chemistry is simply a subset of the overall field of chemistry, and it involves analyzing matter for specific chemical characteristics. The most simple form of analytical chemistry that we consider is you're doing 1 or 2 things. You're either given a material and asked to figure out what that material is, try to identify it, or at least characterize it chemically. Or you might be given a separate material and asked to identify the presence of a specific chemical in that material. Both of those are different forms of analytical chemistry.
This LC-MS instrument basically, is this designed to identify chemicals?
That's exactly right. It's an instrument that is designed to identify the presence of chemicals.
And does it make any difference what the chemical is that you test for in this machine?
Generally, no. As long as the instrument is able to detect that chemical, it can do the identification.
How long has this LC-MS technology been around?
It's been around for decades.
And who would use this type of technology?
Well, mainly chemists, although it's starting to get more and more into the biology area, but primarily chemists are the ones employing it. These could be the chemists in not just forensic applications, but also in food science, in agriculture and the petroleum industry, in athletic steroid testing, in medicine, when they're looking at proteins and things like that, trying to map out proteins. Those are just some of the examples of where it's used.
Are there publications available within the scientific community about the LC-MS technique?
Yes, there are.
Could you describe for His Honor some of those, or how many publications there are?
There are quite a few. I did a search of what's called the National Library of Medicine's database, And in the last 20 years, there were over 1,000 specific articles in just their database. These are published journals articles that dealt with the topic of LC-MS-MS, and then there are many, many more that deal just with the simpler LC-MS technique.
Are there any textbooks on this technology?
Yes, there are.
Do any particular ones come to mind for you?
Well, as I indicated earlier, I was asked to review one of those textbooks. It's called Applications of LC-MS in Toxicology. It's a textbook that was published by a scientist from Italy. His name is Aldo Polettini.
And do you take advantage of reading publications and textbooks just to keep up to date in your field?
Yes, I do.
And again, I would like you to explain to the, and I think you touched on this for the judge, but again, any articles that you have co-authored or peer-reviewed, publications or textbooks in this area?
Yes, there are many that I have co-authored or primary authored.
Could you give the judge an idea of how many and what it means to peer review and some of your co-authored experience?
As far as numbers that I have authored or co-authored, I believe there's about 4 or 5 different articles. As far as peer review, which peer review is simply where a scientist sends a manuscript of their research into a professional journal, and the editor of that journal then reviews what they are writing about, and then goes out to the field to find experts in that particular area and ask those experts to critique the work that was done by that scientist that submitted the manuscript. They usually have a number of suggestions that they send back to the editor, who passes them on to the original author. And then they respond to those critiques, and ultimately a decision is made whether or not it's worthy of being published in that particular scientific publication. I'm often asked to be a peer review for a number of the professional journals in my field of study. Usually I have one on my desk at every moment, essentially to peer review.
Have any of these dealt with the LC-MS technology?
Yes, quite a few have.
And I think you spoke about the availability of publications and the use of this technology, but it is widely used throughout the scientific community, this technology?
It is very widely used throughout the analytical chemistry community.
And what other fields, and I know you touched on this, but I would ask you to amplify a bit on what other fields besides analytical chemistry would find the use for this LC-MS technology?
Well, excuse me, as I indicated, in environmental chemistry, an area where they have used this technique to test water, soil, or perhaps agriculture products. It's also used in food chemistry to analyze different foods for contaminants, for example, or to verify that certain things that are supposed to be in there, they're at a particular level. It is used in the pharmaceutical industry when they're looking for new drugs, drug discovery trials when they're trying to identify new metabolites from drugs. Again, with proteomics, which is studying proteins, it is probably the most widely used instrument for that, and it's used to test athletes for the use of steroids. It is used to look for residues of explosives after a suspected bomb has gone off. Pretty much any organic chemical can be analyzed using this technique.
And has the LC-MS technology been subject to any validation studies by the FBI?
Yes.
Could you describe those for His Honor?
Well, whenever we have a new technique that's introduced into the laboratory, a new instrument into the laboratory, we basically verify that it performs at the same level that the manufacturer claims it performs at. And then we do a number of studies in which we shoot standards that we're used to seeing, chemicals we're used to seeing on other instruments, to ensure that it gives the appropriate response. Then we employ, when it's time to actually use that particular instrument for a procedure that we're going to apply to evidentiary material for a case, we go through a validation study that verifies things such as detection limit. It may verify interferences to that instrument, any matrix effects from the material that we're going to analyze, and a number of other parameters depending on what type of method we're developing.
Basically, what did the validation studies demonstrate?
The validation study simply demonstrates the method's fitness or the instrument's fitness to be used in the laboratory. It identifies the limitations, if you will, to that particular procedure, so you as a scientist can understand where it may not perform at the level that you had hoped to, or in contrast, in kind of supports that it works in the way that you expected it to work. So,
And has this LC-MS technique been subject to validation studies by other colleagues in your field?
Objection. Clarify as to what techniques he's referring to. LCMS.
MS, the LC-MS.
Generally, you're talking about as an instrument?
Yes.
Okay.
Has the LC-MS technique been subject to validation studies by other colleagues within the scientific community?
absolutely. Part of validation, in a way, is the fact that it's published. And as I indicated, in the last 20 years, there are well over 1,000 different articles published by scientists throughout the world that have used the LC-MS technique.
And do you believe that this technique is a reliable and accurate technique and accepted within the scientific community?
Absolutely, it is, yes.
And does the FBI maintain quality assurance measures and procedures to ensure that the testing results are reliable?
Yes, we do.
Could you describe some of those for His Honor?
We use a number of controls to verify that the instrument is working properly, as well as that any procedures that we use on that particular instrument are performing as they're expected to perform. For example, before we use the instrument each day, we inject into what we call a test mic, which is simply a standard of either a group of analytes that we're used to looking at, or in cases in which we're looking for a targeted analyte, looking for a specific chemical, we will shoot just a standard of that chemical daily to ensure that we're getting a consistent response day after day on that instrument. When we're actually running evidentiary material, we introduce negative controls, which are simply closely matched to the evidence, the same type of material that we put through the procedure. We know those are supposed to be negative before we start, and we make sure they're negative when we finish in order to accept those results. Likewise, we run positive controls. These are samples that we know are to be positive before we start the examination, and we ensure that they are positive when they're finished in order to accept the data that came out of that run.
And have you used the term analyte a few times? Could you please describe for the court what you mean by analyte?
The analyte is simply the chemical that we're looking for.
And did you use the LC-MS technique to test for the presence of EDTA in the samples that were sent to you in this case?
Yes, I did.
What is EDTA?
EDTA stands for ethylene diamine tetraacetic acid. And what it is, it's a chemical. It's a chemical that is known as a chelating agent, which simply means it takes metals out of the environment that's in and basically attaches to those metals so they can't be used as they normally would in their free form.
Could you give an example for His Honor about these chelating of this chemical?
Well, one place that we see EDTA used is in poisoning cases where, for example, if someone is suspected of having lead poisoning, they will give EDTA into the body to bind up the lead so it can be absorbed into the body to minimize the toxic effects of that poison.
Where is EDTA found?
Well, it's a pretty much found everywhere these days. And I say that because it's the most abundant man-made chemical that's present in the environment. We have a really big problem with it in particularly in soil and in wastewater and streams and such, because it's been used so much in so many projects over the past few decades that it's become a real environmental concern.
Why does it pose a problem?
Because of the stability, it doesn't go away very easily once it's as itself. But then in particular, when you bind it with a metal, it becomes very persistent.
What is EDTA used for?
It's used in a number of products, commercial products such as shampoos, detergents, where it's trying to take the metals out of the water that make your water hard. It will help remove those metals as you get a better cleaning action with those detergents or shampoos. It is found in the paper industry to help in the bleaching process to make the paper whiter. It's found in agricultural products such as some fertilizers. You see, you see it in foods as preservatives, and then, of course, we use it in laboratory settings.
Is its chemical composition known?
It is, yes.
And have there been scientific techniques or methods available within the scientific community to analyze or test for the presence of EDTA in substances?
Yes, there have been.
Could you describe some of those for His Honor?
Again, they're in all those different areas. So there are methods that are related to food chemistry that talk about EDTA and the analysis of it in food. Same with water and in soil, in commercial products such as shampoos and detergents. So there are quite a few. Again, if you do a search on in databases of published articles for methods for EDTA, I believe there are over 20 that deal with just LCMS techniques. There are over 100 that have been used. There are published methods that are out there in the literature for a variety of techniques.
Now, you use the LCMS technique to test for the presence of EDTA, correct?
That's correct.
Are there other techniques available which could also test for the presence of EDTA?
Yes, there are.
And would you describe them, some of them, please? Some of them?
Well, the LCMS-MS is a very advanced instrument. There are simpler forms of the same technique that could be used. For example, the LC is what is known as an HPLC, a high-pressure liquid chromatograph. That instrument attached to a simpler detector than a mass spectrometer, which is called a diode, DIODE, array detector, could be used. Then you could also use a technique that's called capillary electrophoresis. There are techniques for using gas chromatography. There are techniques for doing what is called a nuclear magnetic resonance spectroscopy and
Excuse me, could you repeat that one more time?
nuclear resonance, RESONANCE. I'm sorry, I misspoke. Nuclear magnetic resonance spectroscopy.
Thank you.
And then you can take nearly any of those instruments, and link them to a mass spectrometer to get the information about the identity of that chemical. It doesn't require essentially the LCMS-MS to do this particular analysis. But I mean, we did employ it because I think it provides specificity and selectivity that is important in a legal proceeding like this.
Would you have these types of instruments that you described?
Any chemistry laboratory, analytical chemistry laboratory, is going to have at least one of those instruments I talked about.
Have any other scientists tested substances for presence of EDTA?
Yes, they have.
And have they published their techniques and findings in peer-reviewed articles?
Yes, they have.
Could you describe a few of those for His Honor?
Well, again, we get into the different areas. There are publications in the environmental studies that have been done looking at the analysis of water, soil. There's agricultural products that have been analyzed by EDTA. The commercial products that have been analyzed for EDTA using a variety of different instrument techniques. The whole gamut. HPLC, GC, capillary electrophoresis, and then any of those techniques linked with a mass spectrometer.
And did you say that these findings and the techniques have been published in peer-reviewed articles?
That's exactly right.
And again, please describe for His Honor, what is a peer-reviewed article?
A peer review article is one.
Asked and answered.
Sustained. I have got that.
Could someone replicate those testing processes?
Yes, they can.
And can the instruments that test for EDTA, shall we say, in agricultural or soil, also be used to test for EDTA in biological substances like blood?
Yes, absolutely.
What is blood collection? What is a blood collection tube?
Well, a blood collection tube is the actual vessel that when you get blood drawn from you, that's what usually a nurse or a medical professional will put the blood into. It's a small, usually glass tube that is under vacuum, and that vacuum helps draw the blood out of your vein into the tube.
Are there different kinds of blood collection tubes?
Yes, there are.
Now, Dr. LEBEAU, you prepared a short PowerPoint demonstration. Do you believe that would be helpful for the judge?
Yes, it would be.
And would you please describe the different kinds of blood collection tubes available?
Well, there are a number of different tubes that are available, and they may or may not have preservatives and anticoagulants in them. We can tell what's in a tube simply by looking at the color of the cap on top of that tube. The red stopper tube, for example, has nothing in it. So when blood goes into it, it's simply blood with nothing added to it. A yellow stopper tube has citric acid and citrate in it. Gray stopper tube has potassium fluoride as well as usually potassium oxalate. And then we also have the lavender or purple top tube that has EDTA in it. Blood is put into those tubes. They're mixed up so that any preservative in them is equally distributed throughout the blood. And the reason that we have these preservatives and the anticoagulants present in the tubes is that because of this is what's called the clotting pathway. We know when we cut our hands or something that the blood will clot to stop the bleeding most of the time. And that's in part largely due to the presence of calcium throughout this cascade that leads to the actual clotting. What the anticoagulant tend to do in the tube of the blood is to tie up that calcium to prevent it from participating in this clotting pathway. So again, if we go back to the red stopper tube, that does not have any anticoagulant or preservative in it, what happens after some time of that blood sitting around in the tube with calcium that's present from our natural diet and just normal metabolic pathways in our body is that calcium helps make those red blood cells clump together or clot. And that, of course, makes it very difficult to use that blood sample in a laboratory setting for doing laboratory testing. So that's why we have tubes like the lavender top or purple top tube containing EDTA. The EDTA structure is listed down on the bottom portion of the screen, and simply what EDTA does, as I mentioned earlier, is it binds metals. Takes metals that are present in that blood sample, such as calcium, to stop the clotting, and iron, which is normally present in our diet, and again, through metabolic processes bind them up so that those metals are no longer available to work as they normally would. And by binding it up, it stops the blood from clotting. Here we have the EDTA in the red blood cells. Again, the iron is floating freely throughout the blood initially, as is the calcium. And once those are mixed up, the EDTA grabs onto those metals, calcium and iron, and binds them and forms a metal complex or a chelate, as I mentioned earlier. But you will notice that there is, in that tube, there is still EDTA present, what we call the free acid from EDTA. That's because they put much, much more EDTA in those tubes than what's actually needed for a standard specimen for it to work as an anticoagulant and preservative. So you will have excess EDTA present.
And I believe you testified that you received blood stains from the Teresa Halbach's RAV4 to test.
That's correct.
And you also received a tube of blood from Stephen Avery.
Yes.
And was that a purple-topped tube?
It was a purple top tube, yes.
And that's the type of tube that you just described.
That's right.
And did you subject those samples to your LC-MS technology?
Yes, we did.
And did you test those samples for the presence of EDTA?
Yes, we did.
Would you describe the steps you took to validate the methods that you used in this testing process?
Well, initially, we had to develop the method, or we had to ensure that the method would work on the instruments that we were employing for this particular technique. Once that was done, we performed 4 different validation experiments. One is what we call our detection limit study. It's simply to determine how low of a concentration of EDTA we can detect using our method. We did this 2 ways. The first way was by taking a solution of EDTA in water and making dilutions of it until we reached a point that we could no longer detect EDTA in that aqueous solution. Then we took a sample of blood not related to this case, but this blood sample had EDTA in it. It was a standard purple top tube that had been filled to the standard level, shaken up, and then we took drops, measured the amount of blood out of that tube. And again, we measured to the point that we could no longer detect EDTA. And as it turns out, with this particular technique, the smallest volume of blood that we can measure out is 1 microliter. 1 microliter is 1 millionth of a liter. At that 1 microliter drop, we were still able to find presence of EDTA using this technique.
That would be EDTA in a purple top tube.
That's exactly right. So that was the one step of the validation we performed, which is our detection limit study. We also looked for interferences in normal blood samples that would interfere with this particular analysis to cause confusion when it came time to interpreting the results. And we did this by analyzing 10 different blood samples that were collected in tubes that contained other preservatives than EDTA. For example, a yellow stopper tube or a gray stopper tube or perhaps a red stopper tube. These are blood samples that were just ran from random individuals. And again, we analyzed that following this procedure and determined that none of those samples, was other blood samples, had interferences in them that would confuse the results. Another part of that study was to ensure that our internal standard, which is simply a control that we put into every sample that we're going to analyze, to ensure that that didn't cause any interferences with our ability to detect EDTA in the samples. The third step was what we called a matrix suppression study. And this is something that is very well known with the use of the LC-MS technique, especially when you use that's what's called electrospray ionization mode, which we did in this case. And simply what that means is that it's a well-known phenomenon that there are other analytes present in a sample that can suppress the signal of the analyte that you're interested in. So what could potentially happen is it makes it look like there's less than what is actually there. We evaluated that to ensure that we weren't getting any significant matrix effect. And at the very worst we got was a 33% suppression in a matrix caused by the matrix, which is fairly insignificant. And then the final study that we did was, I can't think what the final study was. I'm drawing a blank. Can I refer to my notes?
Sure, please.
Oh, yes. Also, a very important study is the carryover study, which was essentially to determine whether or not, if you analyze a sample of the EDTA, does it show up in the next sample that's analyzed. So we evaluated that as well. We did not see any significant carryover effect using this particular technique. And those are the steps that we used in the method validation.
And these steps that you used in the method validation, are these the steps that you normally use in the FBI laboratory to perform method validation?
Yes, exactly. There.
Would you describe for His Honor the analysis that you and others under your supervision performed on the specimens actually in this case?
Well, the analysis, Your Honor, is simply that we focused our instrument to look for two of the products that are on the screen. We looked specifically for the presence of EDTA that was bound to the iron in the blood. And we chose iron over calcium because it is naturally present at about a 10 to 30 times higher amount that is in calcium. And then we also looked for the presence of the free acid from the actual EDTA. Again, that is because there's so much there in an EDTA tube. That's what you should expect to see the most of, unless it's in a case like a poisoning or something, a metal poisoning.
Did you develop a protocol or standing operating procedure for the analysis that you performed in this case?
Yes, we did.
And what is a protocol or a standard operating procedure? Standard operating procedure.
A standard operating procedure is simply the steps that you take in order to complete the analysis. And it's done to ensure that it's done consistently time after time. It includes the information, the background information, and all the materials that you need to perform the analysis, much like a recipe in a cookbook. It tells you what you need and then the stepwise procedure to actually carry it out. But it also includes important things like references you relied upon in developing the procedure and includes the limitations of the method or the results of the validation study.
I'm going to ask if Officer Fassbender could please bring you an exhibit which has been marked as Exhibit 434 and ask you to identify it. Thank you.
All right. Exhibit 434 is the standard operating procedure that we developed for the analysis of EDTA in dried blood stains, especially for this case.
And again, during this analysis, what were you looking for?
Looking for the presence of EDTA in both the free acid form and in the form that's complex to the iron in the bloodstream.
And did you follow this protocol or standard operating procedure that you developed?
Yes, we did.
Is it unusual for the FBI Chemistry Unit lab to receive requests to analyze some substance for a chemical that you have to develop a protocol for?
Not at all. Many of the cases that we receive in our unit in particular would normally be worked by a state laboratory. But for a number of reasons, they're sent to our laboratory, primarily because either it would be very taxing on that state laboratory to take people off their normal casework in order to develop a method, validate the method, and then put it into use. Or they may, in other cases, they may not have the expertise or the personnel in order to do that. So many of our requests that come in are to analyze for unique or new drugs or to apply new technique to a particular analyte. And so we're very, very familiar, and it's a normal course of business for us to have to develop a method, validate it, and then apply in this case.
Was there anything in the literature that helped you develop this standard operating procedure that you used in this case?
Yes, there certainly was.
I'm going to have handed you two exhibits which have been marked Exhibits 436 and 437. I ask you to look at those, and I ask you, do you recognize those?
Yes. Exhibit 436 is a manuscript out of the Journal of Analytical Toxicology published in November-December of 1997 that's entitled The Analysis of EDTA and Dried Blood Stains by Electrospray, LC-MS-MS, and Ion Chromatography. And this is the primary article that we relied upon in order to develop the method in this particular case. The second article, Exhibit 437, is from a journal that's entitled Analytical Chemistry. And the title of the article is Determining EDTA in Blood. And again, we relied upon this article to help us along with the way as we were developing and analyzing specimens in this case.
Do you consider those articles or publications to be peer-reviewed articles?
Absolutely.
And could someone take those articles and develop a testing procedure for EDTA in blood?
Yes, they could.
And if someone wanted to, Could they make improvements to the methods addressed in those two articles?
Yes, they can.
Could you again just state what was the date of the second article, Exhibit 437?
Yes, that is August of 1997.
For my benefit, these are the first two listed items. Under 16, references on the looks like page 8 of the attachment to your submission.
That is correct, Your Honor. And were the instruments used in those articles similar to the instruments that you used in your testing in this case?
Yes, they're similar, but not exactly the same.
Could independent researchers, university research facilities, or other forensic labs adopt those procedures and develop a protocol for testing EDTA in blood?
Yes, they could.
Did you make any improvements to those articles?
We did.
Please describe for His Honor the improvements that you made to existing protocols.
All right. Probably the most significant improvement I think we undertook when we developed our method is we introduced what's called an internal standard, as I alluded to earlier. This is simply for each samples, we're adding a positive control to that actual sample. It's a chemically modified version of the same analyte that we're looking for. It's simply made a little bit heavier than the normal analyte. And it allows us to get a very accurate assessment as to if the actual sample itself worked, not just the batch run of samples, but it allows you to assess each individual sample as to whether or not it should pass or fail your quality assurance protocols and quality control protocols you have set up. We introduced that, which neither of these papers did. We also we looked for the presence of the free acid from the EDTA in one of the techniques that the first reference, Exhibit 436, did not look for. So we added an additional test, if you will, to our protocol that allowed us to kind of take three-pronged approach to looking for EDTA in these samples. And furthermore, we used a different LC-MS instrument that was used in this the 1997 article in the Journal of Analytical Toxicology. The instrument we used is newer than the one they used in this particular procedure, and improvements have been made that I believe helped us eliminate one of those concerns that they reported in this particular paper, and that is of a carryover of the samples from one sampling to the next.
What is a scientific hypothesis?
Well, it's an idea that a scientist has that then they're going to apply research, if you will, to either show that their idea is accurate or if it's inaccurate.
Did you develop a scientific hypothesis for this case before you did your testing?
Well, we did, yes.
And what was that?
Again, if I can go to this presentation, the idea was what we were asked to do is determine if someone took a purple stopper tube of blood that has EDTA in it, takes the cap off the tube, and then pours a drop or many drops out onto the surface. If someone comes along at a later date, swabs up that dried blood stain, are we able to then find on that swab from that stain the presence of EDTA and EDTA linked with iron? That's the scientific hypothesis, is what we should be able to find the presence of free acid EDTA as well as the EDTA that's bound to iron off of that stain that's on the swab that's collected from a blood stain.
And were you able to do that in this case?
We were able to perform that analysis, yes.
And what was your conclusion?
Well, we did not find any EDTA or EDTA bound to iron on the swabs that we received in this case.
Were controls run with each analysis that you ran with the blood stains submitted to you?
Yes, they were.
Explain what controls are.
Again, we ran negative controls. These were blood samples that were not put into an EDTA tube, and then samples of the blood were applied to swabs. Those swabs were carried through the whole extraction procedure. They were to be negative from the start, and at the end of the analysis, they were indeed negative. We ran positive control samples. We did this two ways. We ran a positive control sample of blood from a lab volunteer who, again, their blood sample was put into a purple stopper tube that contained EDTA. That blood sample we expected to be positive at the end of the run, and it was indeed positive. But additionally, we took the blood sample that was provided to us from Stephen Avery. We put that on the swab and ran that through as a positive control. It should have had EDTA in it because it was in a purple top tube, and it did indeed have EDTA in it, served as a positive control. And then, as I alluded to, the internal standard that we introduce into every sample, that is another control that allows us to assess that their actual sample worked as expected. So that was a third type of control we used.
I would like to stop because I'm not following something. I thought in the exhibit up on the PowerPoint you said that you took some blood out of a purple tube, spilled some of it out, tested it with the swab, and did not find EDTA or EDTA.
I'm sorry, Your Honor, if I could just go back. I was asked about the scientific hypothesis that we had for this particular case. And the hypothesis being that if anyone, were to take a tube of blood that contains EDTA and put some of that blood somewhere, and then someone else comes along and samples that blood, that EDTA blood should transfer onto that swab.
It should.
Should, yes.
Okay.
And the idea is, the whole premise behind our protocol that we developed was that we should be able to find EDTA and EDTA bound to iron on that swab. And our validation showed that we can do that. We absolutely can do that. Then I was asked about the results in this particular case. And the results in this particular case, with the swabs we received, we did not detect EDTA and EDTA with iron linked to it. So this is specifically for the results on the case at hand today.
When you say the swabs you received, what swabs are we talking about?
He was sent 3 swabs, three of the ones that Sherry Culhane testified to, A8, the swabbing from the ignition, by the dashboard, by the ignition, A-8.
You want to let him testify as to what he tested?
Would you tell him?
I think this line of questioning was designed to elicit that. I didn't get it, so I think you better go back and do it again.
All right. What did you receive to test in this case?
Okay. We received 3 swabs, ones that were collected from the RAV4. One swab was reported to have been collected from near the ignition switch in the car. Another swab was off of a door panel area. And the third was off of a CD case.
And those were sent to you and you subjected those to the LC-MS testing. Is that correct?
That's correct.
And what were you looking for in those swabs?
We were looking for the presence of EDTA in the free acid form of EDTA, as well as the EDTA that's bound or complexed with iron.
And were you also sent a tube of blood from the Stephen Avery that came from the Manitowoc County Clerk of Court's office?
Yes, I was.
And what, did you test that tube of blood?
Yes, we did.
And what did you test it for?
Presence of EDTA and EDTA bound to iron.
Did you find EDTA in the tube of blood of Stephen Avery?
Yes, we did.
Did you find EDTA in any of the 3 blood-stained swabs from Teresa Halbach's RAV4?
No, we did not.
Now, would you just relate to His Honor how that testing process fit in with your original hypothesis in this case that you developed?
Well, the idea was, as part of the validation of the method, is that you can actually still find the presence of EDTA, even if it's collected onto a swab and then sent into the laboratory, essentially.
So you're either going to find EDTA or not EDTA in the swabs from Teresa Halbach's car.
Exactly.
And you did not find.
We did not.
Would you tell His Honor about your experience? No, I take that. Strike that. Are there articles about the denigration of EDTA?
Yes, there are. There are numerous articles. There's even chapters in books talking about the degradation or, conversely, the stability of EDTA.
And tell the judge about your experience with the stability of EDTA and any tests that you may have run in conjunction with this case.
Well, specifically in this article that we relied upon, the Journal of Analytical Toxicology, they talk about it in relation to old blood stains. They looked at blood stains that were 2 years old and were still able to identify EDTA after 2 years of storage at room temperature. Likewise, we performed a similar analysis in our lab in which we looked at blood stains that had been put onto cards, spot cards, EDTA blood that had been placed on the spot cards in May of 2004 and stored at room temperature up until they were analyzed just last week. And we were able to identify the presence of EDTA in every single one of those.
I'm going to have handed to you an exhibit which has been marked as exhibit, I believe, 435. And could you explain to the court what that exhibit is?
This is a copy of the laboratory report that I issued for this case.
And I would like you to explain to the court a little bit about the detection level. How low could you go in detecting EDTA in this case?
Well, I can explain in two ways. One way is talking about concentration of EDTA. And as I explained earlier, we were able to do decreasingly lower and lower concentrations of EDTA in a water solution. At that, using that technique, we could identify 13 micrograms per milliliter of EDTA. And that's it's a number. It doesn't necessarily mean a whole lot unless you are a scientist. But likewise, what we did is we took a tube of EDTA blood and we did spots of that blood to the lowest volume that we can accurately measure, out of which is 1 microliter. And even that 1 microliter drop of EDTA blood, which is the equivalent of about 1/20th of a drop of blood, even that little amount, we were able to find the presence of EDTA in it.
Based upon your training and experience, and based upon your test results using the LC-MS-MS technique, and based upon all the data and compilations that you have reviewed, and basically the entire case file that you have, do you have an opinion, to a reasonable degree of scientific certainty, whether the blood stains from Teresa Halbach's RAV4 that you tested came from the vial of blood from Stephen Avery, which was in the Manitowoc County Clerk of Court's office?
I do have an opinion on it.
What is that opinion?
My opinion is that the blood stains did not come from that tube of blood.
Thank you. That's all I have.
You want to take a break now, or do you want to start?
Let's take a 10-minute break, and then we'll come back to your cross.
Okay.
And Mr. Butin, at this time you may begin your cross-examination.
Thank you, Your Honor. Good morning, Mr. LEBEAU.
Good morning.
Let's talk a little bit about your background. Do you have the CV in front of you?
Yes, I do.
As I look at it, if you turn to page, do you have anything in here that shows research interest? Do you have a heading that says that, or am I wrong? Do you have a heading like that, a subheading that says research interests?
I don't notice one.
Well, let's go ahead and mark this. I'm going to show you Exhibit 438. Can you look through that and identify it for us?
Yes, this is a declaration that I made in another case involving EDTA.
Okay, and that's a case called State of California versus Cooper.
That's correct.
We'll talk about that in more detail later, but attached to this declaration, you had also a CV, I believe, and this was filed in, declaration is dated April 28 of 2004.
2004, that's correct.
Okay, and I recognize that CVs can change from time to time, right?
That's right.
And the one that you filed here today, it being 2007, is going to be somewhat different than the one you filed in 2004, right?
That's correct, yes.
But in this particular one, you did have a section called research, areas of research, right? Highlight it for you there.
Yes, I did.
Okay, and at least as of 2004, you described your You listed 6 areas of research interest, okay? Would you agree with me?
Yes, I do.
The first one, which you dated as 1987 and 88 only, was trace element analysis of hair, right?
That's correct.
1989, statistical analysis of suicide deaths, right?
Yes,
1991, nebulizer administration of can you pronounce that for me?
Ceftriaxone.
That's CEFTRIAXONE to follow, right?
That's correct.
Some antibiotics for chickens or something.
Yes,
Okay, and then 1991 to 1994, you put postmortem redistribution of drugs.
yes,
And then at least as of 2004, the only one research interest that you put as still present was 1998 to the present, detection of drug facilitated rape, right?
that's correct.
And 1999 to present, GHB and drug facilitated sexual assault.
That's correct.
More or less the same.
One's a broader topic than the other, but yes.
Okay. And would it be true to say that if you were to add this section to your CV right now, updating it to 2007, these would probably say 1998 to present still?
No, the research section of that old CV from 3 years ago were different topics of research that I had engaged during my course of study at different universities. So, for example, the last 2 items, detection of drug-facilitated sexual assault and GHB in drug-facilitated sexual assault, those were my dissertation topics for my doctorate. The topic about trace elements and hair, that was an undergraduate research project that I did at the Central Missouri State University in Warrensburg, Missouri, was part of a senior lab project. The ceftriaxone in fowl was a graduate research project I was employed upon at my job when I was working at the St. Louis County Medical Examiner's Office. It was a side project that my supervisor asked me to work on that with him, and
So let me just stop you for a second then. So what you're saying is those research areas we just described are only research that you did while you were engaged in some educational pursuit.
in an academic, towards an academic degree. That's what the specific research projects listed on that old CV.
So in 2004, when you list the detection of GHB drug facilitated rape as a research area, you said 1988 to present, you were still working on your PhD at that time.
Yes, I was.
Okay. And you have since completed it?
Yes, I have.
So you no longer are involved in any research at all?
I'm not involved in any research in an academia type setting. Certainly, we do research to a small scale with cases as we're asked to be involved with them.
Sure, but
not long-term research like you would expect towards a degree.
And when we're talking about academic research, we're talking about publications, peer review, things of that sort, right?
Well, that's one part of doing research in academia, that's correct.
Doesn't help me much if you are in a laboratory doing an experiment on your own, devising something, if you don't publish it and tell other people what it is, right?
Well, I mean, you can't publish everything you do, that's certainly true. But we do publish methods, for example, that we develop that are unique and not already out in the scientific literature. We will publish and put it in through the peer review process.
Okay, we'll get to that into that in a minute. But as I look at your presentations, the talks that you give from 1988 to 1998, to now, looking at the new CV, the huge majority of those presentations are on this topic of GHB and drug-induced rape situations, like, right?
That's correct.
In fact, you're speaking to in just a couple of weeks in a women's sexual violence seminar, aren't you?
I may be. I don't know my schedule that far out, actually.
You don't know that you're speaking on March 23rd?
I could very well be.
You haven't written a paper on it yet?
I may have. I do quite a bit of training on that particular topic.
So do I understand though that you don't even know that you're giving a talk on March 23rd now?
No. What you understand is I don't know my calendar 3 weeks out.
Okay, and when I say the great majority of your talks are on that one topic, would you agree probably over 90% of the talks that you've given since 1998 are focused on that one issue?
It's a topic that I'm well recognized in this country for being an expert, and so I'm invited to do a
Sure.
whole lot of training on that particular topic.
And that has been, as far as peer review of any of your research, that's been it. That's where you've gotten the recognition, and the most peer review is on your work on the detection of GHB in sexual assault cases.
No, I would disagree with that. It's certainly an area that I have done a considerable amount of publication on and personal research towards my doctorate, but there are numerous other publications that I have been involved with that fall outside the area of GHB in drug facilitated crimes.
Okay, well, let's talk about your experience with EDTA. You've never tested for EDTA before this case, have you?
Yes, I have.
When?
Approximately 1998.
And was that the O.J. Simpson case?
No, it wasn't.
Were you working for the FBI?
Yes, I was.
And were you using a protocol?
Yes, I was.
And Mr. Gahn forwarded you a letter that I sent requesting copies of information.
Yes.
One of those was a request for any and all protocols that you have ever used testing EDTA.
Yes.
You didn't provide that, did you?
No, we did not.
All you provided was your current protocol, right?
That's correct, because this is the protocol we use for this case.
Well, how many times have you tested for EDTA before this case?
One other time.
One other time. And it was a protocol that you no longer use. Is that right?
I believe we still use a revised version of the protocol I used in the previous testing for EDTA, but it was not the same type of scenario. We weren't
No.
looking for EDTA in a blood stain, which would, in my opinion, require a little bit different approach
It sure does.
to analysis.
What were you testing for in that case?
EDTA.
In what?
I'm sorry?
In what?
In a buffer solution.
In a buffer solution?
Yes.
Why would you find EDTA in a buffer solution?
Well, as I indicated, it's used in laboratory settings, and it was a case involving allegations of a wrongdoing by a forensic lab employee purposefully mixing up a buffer, contaminating it with EDTA, switching buffers. So we were asked to investigate the buffers to see if they had indeed been switched.
Okay.
And that's what it involved.
And were they? Did you find evidence of it?
I don't recall, actually.
Really? What lab was that?
I don't recall.
Wasn't that right around the time when the FBI lab itself was being challenged and audited for the very same sorts of concerns?
No, not at all. We were not audited for purposefully mixing up buffers and as a disgruntled employee trying to get back at the organization.
I see.
Not at all.
Well, you were audited by the Inspector General of the United States,
Yes, we were.
and that was in 1999.
I don't recall the date, but it was in the late 90s. You're right.
And it was part of an evaluation of the whole FBI lab, not just your unit.
It was overall the practices within our organization and in our laboratory.
And how many different units do you have in the FBI laboratory?
Today,
Or back then?
it's going to be a different answer, so
Well, give me back then.
approximately 25 units.
Okay, and how about today?
Probably around 30 yesterday.
Okay, and of those 25 units, the chemical unit was one of the units that was audited by the Inspector General, isn't it?
Well, all the units were looked at and the practices of the FBI laboratory were looked at. Our unit was one of the Inspector General came in and specifically was looking at allegations made by the individual that initiated the complaint. His allegations against one employee within our unit.
And
that's how we were looked at.
And the allegations involving that employee concerned a test very similar to what you're doing today, or what you did in this case, that is, a test for EDTA in bloodstains, right?
Could you repeat that?
The individual and the reason that your unit was audited by the Inspector General concerned an EDTA test and a bloodstain that was done by your lab, right?
That's not my understanding of why our unit was the one that was looked at by the Inspector General. You would have to actually ask the Inspector General why they looked at our unit.
Well, you are the unit chief.
I am now, yes.
And you are responsible for quality control.
I am, yes.
And if the Inspector General audits your lab and comes up with some recommendations or suggestions, you're going to know that, aren't you?
Well, when the Inspector General was looking at our unit, I was still an examiner. I was a bench scientist. Since then, there was another unit chief, and then I became the unit chief. So there was a number of other managers prior to me.
So you've never read the Inspector General's report auditing your unit?
I read the Inspector General's report it was a very large report. I read the executive summary of that report, and I read specific allegations against the individual in the chemistry unit.
Right.
To see what their criticisms were towards him as an educational lesson.
And that individual, which exhibit is this, 437?
That is exhibit 436.
Exhibit 436. That individual is one of the authors of this exhibit 436, correct?
That's correct.
That is Mr. Roger Martz, right?
That's correct.
And the audit and the allegations that were investigated concern Mr. Martz's involvement in an EDTA test on a bloodstain in a case. Isn't that right?
One of the areas that the Inspector General did look at was how Mr. Martz testified in the O.J. Simpson case in regards to EDTA.
Fine. Thank you.
The presence of blood, amongst a number of other things that were allegations made by Mr. Whitehurst against numerous employees in the FBI laboratory.
All right. The FBI lab, Exhibit 436, by the way, this article that is supposedly a published peer review article.
It is not supposedly, it's a published and peer review article.
It is. Let's just get clear who wrote it, okay? All of the authors are FBI lab members, right?
They were at the time of this publication, yes.
Okay, so this article was written by FBI people, correct?
Yes.
And it was written after the O.J. Simpson case, right?
That's correct, it was.
And in that case, the issue of a possible stain having EDTA in it came up in sort of the middle of the case, right?
It did, yes.
And your lab developed a protocol kind of in the middle of that case, right?
Yes.
And that was the first time your lab had ever tested for EDTA on a bloodstain, right?
I believe that's true, yes.
And how many times after that did your lab ever test for EDTA in bloodstains?
Never.
So until this case, the FBI has not tested for blood, EDTA in bloodstains again since 1996. I think this was, right?
Yeah, I believe it was 1996 when the OJ case was going on.
So in 10 years go by even after the FBI publishes this peer review article. 10 years go by before the FBI again tests for EDTA, which is this case, right?
That's correct.
And you, in fact, have, as we indicated in that declaration, Exhibit 438, you have come out on the side of the government against defendants who seek EDTA testing of bloodstains in their cases. Isn't that right?
No, that's not right.
In the Kevin Cooper case, didn't you object to the testing of the EDTA stain in that case?
No, I objected to the technique that was used in order to do the actual testing in regards to how an estimation of the size of the sample, blood sample, was obtained, as well as what appeared to me to be the lack of appropriate controls used by the scientists in this case.
All right. Well, we'll talk about that a little bit more in a minute. Let's get this clear then. Let's just get it clear then. Ever since the O.J. Simpson case, until this case of Mr. Stephen Avery, the FBI has never tested for EDTA in a bloodstain on any other case in this country.
FBI laboratory has not received a request to test for EDTA in a bloodstain from OJ. The OJ case until this case, and it's been approximately 10 years. That's a correct statement.
And Exhibit 437 maybe explains why. Do you have Exhibit 437 in there?
Yes, I do.
Exhibit 437 points out that there was some problems in the EDA test protocol that was used in the O.J. Simpson case, correct?
On what page are you referring to?
Well, the bottom of the first page and top of the second, that paragraph that says what was wrong with the laboratory testing. Do you see that?
I do.
What it says is, quote, what was wrong with the laboratory testing? First, it was not clear whether the method had ever been used before, close quote, right?
That's right.
In fact, the method had never been used before that case, right?
That's correct. Not the method that we used in the OJ case. It had never been used in that manner before.
In that manner, correct? For EDTA stains, right? In blood.
That's correct.
Most likely, continuing the quote, the method was developed quickly under a great deal of time pressure. Okay?
Yes.
And is that true?
Yes, that's true.
And in retrospect, FBI chemists now believe that the EDTA detected may have been injection carryover in the LC-MS instrumentation, right?
That's correct.
And so that particular protocol that was developed and published and peer-reviewed in that you have in front of you as 436, the peer reviews found flaws in this protocol, didn't they?
No, absolutely not. That is, this analytical chemistry paper published in August of 1997 cannot be considered a peer review of the article that was published in November of 1997.
Well,
This one is published prior to this one, and the author of this would never have seen this until it was published.
Have you ever seen any article, any peer review response anywhere to Exhibit 436, this FBI published protocol in the testing?
Yes, I have.
Where? Can you cite to it?
Yes, a peer reviewed that article.
Oh, you?
Internally.
Internally.
Because part of the FBI laboratory's requirement is before we publish any article. Excuse me, I'm not finished.
Yes, you are. This is a cross. You can explain yourself later, sir. Thank you.
Wait a minute. That's part of his answer to the question you asked. I'm going to allow him to complete it.
So, Your Honor, as part of any publication that employees at the FBI laboratory put out, we're required to have an additional peer review step conducted by employees within our organization to ensure that the science is valid, so we don't embarrass ourselves before it goes out to a peer reviewer. I was an internal peer reviewer on the article that is in the Journal of Analytical Toxicology, and I made comments on that article and sent it back to the researchers that were involved in it. After my comments were addressed, it then went out to the actual journal, and that editor of the journal employed some reviewers to look at it. Now, I don't know who those reviewers were, and I never saw that review.
As a matter of fact, you mentioned, so the FBI is not embarrassed. The FBI was embarrassed by the EDTA stain test in the O.J. Simpson case, weren't they?
I would disagree.
Well, they never did it again, did you?
We were never asked to do it again. We don't control the cases that come into our laboratory. Law enforcement agencies ask us for their assistance, and if we were able to provide that assistance, we will.
Do you know?
But if you were not asked to do the test, we don't have control over that.
And of course, defendants can't ask you to do tests, can they?
That's correct. We're a law enforcement agency, and the funding that we get from the U.S. Congress is to support law enforcement investigations.
Okay.
With the results.
You are aware, though, that over the course of the year, the last decade, there have been some cases where defendants have sought to do some sort of EDTA test on bloodstains, right?
Yes, I am.
Most often post-conviction cases, right?
Yes.
Like the Kevin Cooper case.
Yes.
And would you agree with me that in every one of those cases that you've heard of, the government has been opposing the use or the protocols or the methods that a defendant has used to try to get EDTA stain evidence in, blood stain evidence in?
I don't believe they were opposing the idea of testing of blood stain for EDTA. My understanding, and I'm only aware of 2 cases, my understanding is that they were opposing the approach that was taken by the scientist, that he didn't use good science. The techniques that he employed, the instrumental techniques, as we talked about in direct, these are techniques to identify chemicals. So a chemical is a chemical.
Sure.
But if you don't apply good science to getting to that answer, that's what becomes in question. They weren't my understanding is his approach was not a well-validated approach.
And his approach, when you say his, we're talking about Dr. Kevin Ballard, right?
That's correct.
At the National NMS, what's it called? National Medical Services Lab?
That's correct.
And you disagreed with his protocol?
I didn't see his protocol. I disagreed with the approach.
Okay.
That he testified to in the Cooper case, I believe it was.
Okay. Can you tell us of any lab anywhere in the world that has ever used the protocol that your colleagues published in Exhibit 436?
There would be no way to know that. We don't, there's not a database that people have to report to us if they are choosing to take a journal in an article out of a public journal and use it in their own laboratory.
Well,
we would never know if they use it or not.
Well, let me just give you an example. Oftentimes, people publish, in fact, there are some articles you cited on the use of LS-MS-MS for a particular technique, right?
LC-MS-MS.
I'm sorry, LC-MS-MS, right?
Yes.
And by the way, there's a slash between LC-MS. That's the way it's written.
That's correct.
And oftentimes in academia, what researchers will do is they will take one test that's published and they will test it, report back whether they get the same results, right?
That's common when you're dealing with like a breakthrough in a new area of science.
Sure.
You might have multiple researchers from different research teams working independently, yet together, to prove that a new scientific hypothesis is actually working as they expected.
Sure, that's what science is, right? The whole idea that you can replace someone else's study,
That is part of it,
replicate.
yes.
And
Yes.
can you tell me of any article anywhere of anybody who ever studied and replicated or tried to replicate the test or the study that's reported in Exhibit 436?
Yes.
Who?
Me.
Oh, okay. Anybody besides you?
Not that I know of.
Okay. And Exhibit 437, analytical chemistry article entitled Determining EDTA in Blood. They used an entirely different method, didn't they?
No, absolutely not. They used a very similar method. The only difference is instead of using a liquid chromatograph on the front end to the separation of the components into their individual components, if you will,
They used a capillary.
they use the capillary electrophoresis, which does the exact same thing, and it's based in a very similar principle, just uses electrical currents and charges to cause the separation.
But the protocol, the test they did, is not the same as reported in the FBI lab article, is it?
Well, they're doing mass spec to actually do the identification of EDTA. And it is very similar to what is published in the independently done publication in the Journal of Analytical Toxicology.
And we're talking about this article by Robin Shepard and Jack Henyon, who at the time were associated in some way with Cornell.
That's correct.
Do you know them personally?
I do not know either one of them personally.
Do you know that neither one of them is with Cornell anymore?
I don't know that.
Okay, but their study was trying to do something more. Their study was actually trying to see if they could quantitate the amount of EDTA, right?
They were, yes.
And your protocol that you used in this case, which is exhibit, 434? It's up there.
The protocol was, I don't believe I have the protocol.
Well, you're familiar with it. Oh, I've got it with me. I'm sorry. I thought it was just a copy. This protocol 434 does not attempt to quantitate the EDTA if it's found, does it?
No, it does not.
It's simply trying to see if there's any way you can detect the presence of EDTA.
That's exactly right.
Okay, this protocol, which is Exhibit 343, has a date of February 15th, 2007, right?
That's correct.
And until that time, until this protocol was developed for this specific case, the FBI had no existing protocol to test for EDTA in a bloodstain, correct?
I don't believe that to be correct, no.
Well, let me go back for just a minute because perhaps we've been misinformed. Maybe I've been misinformed. When were you first contacted by any prosecutor, law enforcement agent, or whatever involved with Mr. Avery's case?
In December of 2006.
So between February of 2006 and December of 2006, nobody from the state contacted you, right?
Between February of 2006 and December of 2006, not that I recall, no.
Nobody called you to say, hey, we've got a case where somebody is claiming that evidence was planted and we have some bloodstains in this vehicle. We would like you to test for EDTA. Is that right?
That's correct.
It wasn't until December that somebody first contacted you from the prosecution team, right?
To my recollection, yes.
That would be Mr. Gahn?
That's correct.
Okay, is there any reason why you would have been unable to develop a protocol like this any time between February of 06 and February 15th of 07 when you actually did develop it?
No.
So if the state had contacted you a year ago and said, hey, we would like to test for these stains. We know this guy is claiming that it was planted. We want to rule out this ridiculous defense. You could have developed a protocol any time within that year, right?
Yes, we could.
Okay. Now, when you spoke with Mr. Gahn in December, what did you tell him about whether you could do this protocol?
I said we could.
Did you tell him how long it would take?
I probably gave him an estimate about how long it would take us to get to it.
And what was that estimate?
I generally say about 4 to 6 months.
All right. And did he explain to you that, hey, we've got a trial date coming up on February 5th. That's not going to work?
He did.
And did he ask you for the fastest? We're talking December now. Did he ask you what's the fastest turnaround you could possibly give us to get this test done?
I believe he did.
And you told him 3 to 4 months at that time.
I don't know what my response is, but it was probably in that range, 3 to 4 months.
And one of the reasons you told him that was that you had no working protocol that would be allowed to be used in your accredited lab.
I think that's the message getting a little mixed with an in-between messenger. What I told him was that since we had moved our laboratory in 2003 from Washington, D.C. to Quantico, Virginia, we had acquired a number of new instruments, and a number of the instruments that we had at the old laboratory did not come with us. So what that involved is if we had not used any protocol that moved with us to the new laboratory, we had to essentially revalidate to some extent if we were putting it onto a new instrument that the instrument that had never been used before for this particular analysis. So my message to Mr. Gahn was that we had not used the protocol since the OJ case, and that we would need to bring it up to standard with today's accreditation standards for our accrediting value. We would have to make sure that it met all of our internal quality assurance requirements, because since the OJ case, we have gone through 4 different quality assurance systems in our laboratory. Each one is another step up.
Sure.
As far as requirements. So we had to ensure that this protocol that was used in the mid-90s met the standards of 2007. That's essentially what it was.
Okay. And you told them because of all of that, calibrating the instrument and validating a new protocol, it would take a matter of months, right?
Yeah, that's my general response to any time we're asked to develop a new method and validate it. I generally say 4 to 6 months because we never know what major cases are going to happen in this country that can, divert our resources to other investigations.
Okay, but then in January, somebody else contacted you, is that right?
You will have to refresh my memory.
Did anybody else in January contact you again to see if that whole time frame could be changed?
I don't know when it was, but I did get a call from one of our special agents in the local field office asking me if we could help out in this case. But but as I explained to him at the time, we had already agreed to help out on the case, and that we were going to start doing something that's rather unprecedented for us. We were actually going to start working on the case before the evidence actually got to us, meaning we were going to start doing the method validation test, anticipating that this evidence was actually going to show up.
So that unprecedented is the word you used, right?
Unprecedented in that we actually start to do work on a case before it shows up into our laboratory.
And tell the court what changed. How is it that in December it was going to take 3 to 4 months to develop a protocol, validate it, calibrate the instruments, and suddenly now the time frame was shortened to a matter of 3 or 4 weeks?
The time frame wasn't shortened. There were no guarantees that we would get it done, never made a guarantee that we would. But what changed was simply we applied ourselves to that and no other case. Myself and some of my staff, this is what we worked on. And we worked long hours. There were weekends involved. They were, more than the standard normal hours of operation. That's what happened. We decided that we would help out. We committed that we would work out on the case and we would try our best to complete all of the work that was required in order for it to be here during this court proceeding. But again,
Okay.
we could have failed, quite honestly.
And by the way, you mentioned long hours. Does the FBI lab run 24 hours a day?
No, it doesn't.
Well, what are your normal hours?
7:30 to 5.
In the month of February, did you ever arrive at the office or the lab before 7:30 in the morning?
Yes, I did.
What time?
Probably 7:15, 7.
So the earliest you ever arrived was 7 a.m.?
The laboratory opens at 7 a.m.
Okay, but in this case, there were actual analysts working even earlier than that, right?
No,
Like 5 in the morning?
no.
All right, we'll look at some of these sheets later. Perhaps I'm just misinterpreting them. So, at any rate, when did you tell Mr. Gahn that you thought, "Hey, I can get this done quicker if we work weekends and apply ourselves"?
I never told him that.
You never told Mr. Gahn that you could get this test done before or in time for a rebuttal of the state's case?
No, like I explained, I said we would try our best to get it done, but I never guaranteed we would.
But while you were doing it, you knew that you had the time pressure of the trial already beginning, right?
Yes.
In fact, the protocol wasn't validated until February 15th, right?
No, that's not correct.
Well, what's the date of February 15th on there mean?
That's the date that the protocol was issued.
Okay,
If I can explain the process we go through to bring our
go ahead.
protocol online. The first thing we have to do is we have to develop the method. And in this case, we had the luxury of having a published reference to go to. So we didn't have to start from scratch. We simply went to that method. We used the same parameters that were published in this paper from the Journal of Analytical Toxicology, the same parameters.
You're talking about, so we're clear, you're talking about the form of protocol that the FBI used in the OJ case, right?
Well, this isn't exactly the protocol that was used in the OJ case. This is not exactly, there are things done in this paper that were not done in the OJ case.
Exhibit number what?
436.
436, yes.
Okay, so you looked at that and then you worked off of that to develop this new protocol.
Well, we essentially set up our instrument so that it was giving results comparable to what they were talking about in this paper, meaning just injecting standards of EDTA into the instrument, not with blood or anything.
You can tell us when those first steps began?
That was very late January into early February.
Okay.
And then after we had have the instrument working the way it's supposed to work, set up, we started our actual validation steps. And this is, as I described earlier, these are the steps to ensure that the method is fit for its intended purpose. So for us to identify any limitations in that particular procedure that we can then use if we're trying to interpret data.
And on what date was that protocol validated, in your opinion?
All of the validation work was done before the middle of the month, before the 14th of February.
Okay.
And then it has to go through a review process.
All right, so
By scientists that are not involved in the actual validation study. So an independent group of scientists looks through all of the validation data and to sign their name that they agree with the work that was done and the findings of the validation study.
let me stop you there for 1 second. A group of independent scientists. You're talking about FBI people?
That's right.
Not outside independent labs, right?
That's correct.
Not other academic researchers, right?
Yes, that's right.
And this protocol, for instance, has not been peer reviewed like it would be if it's published like our exhibit 436, right?
Well, the changes were very minor from off of the published
Sir,
protocol.
This protocol, Exhibit 434, has not been peer-reviewed by anybody outside of the FBI lab. Is that right?
Sir, very few of our protocols are reviewed by anybody
Judge,
outside the FBI laboratory.
He's entitled to an answer to his question.
No, this was not peer-reviewed by anyone outside of the FBI,
thank you.
as it's written here.
That's right. And the protocol did not arise out of any kind of ongoing research independent of this litigation, right?
I'm not sure I understand your question.
Oh, you understand the question. The development of this protocol was not something that just came out of independent research your lab was doing on determining whether or not you could find EDTA in bloodstains.
That is correct. This was generated specifically by the request to do the analysis of evidence in this case. That's why we developed this
Sure.
protocol.
So it's specific to this litigation, right?
And then future cases if we get the request.
And there were no industry standards that bound you to this particular protocol, right?
No, I disagree. There are certainly standards that we have to employ that are based on the FBI Laboratories Quality Assurance Program, and those are very straitened protocols and requirements that are in essence based upon our accrediting body's requirements. And that we have actually stepped up to a more stringent accreditation program where we're following what's called the International Standards of Operations, or ISO protocols. And
Let me stop you there for a second because a lot of your testimony on direct was about this LCMS technique. I'm sorry, LCMS technique, right?
that's correct.
Just so we're not confused, I'm not attacking that particular instrument, okay?
Okay.
I'm not challenging the ability of that instrument to find, in some circumstances, certain chemicals, okay?
Okay.
Are you with me?
Yes.
So what I'm trying to focus on here is the use of that instrument to attempt to find EDTA in a bloodstain, all right?
Yes.
And that's what your protocol 434 was developed to do, right?
Yes, it was.
And now you were not bound by any kind of industry standards in the development of the protocols, hypotheses that you were trying to find EDTA in a bloodstain.
I'm sorry, but I'm not sure I follow you.
It's probably a bad question. I apologize. It's my fault. Let me go at it this way. As far as you know, is there anybody else in the country who is doing testing for EDTA stains? I'm sorry, EDTA in bloodstains.
Yeah, I believe that the lab you referred to earlier, National Medical Services, is offering that.
And that's Mr. Ballard, right?
He's at least one of the scientists that performed that analysis. I'm not aware if any other do or do not.
Okay. And you're not aware of any other lab that does?
I'm not aware of any that do that, and the only reason I'm aware that National Medical Services offers it is because of the Cooper case, as we talked about earlier.
Would you agree there is a rather conspicuous void of research in the last 10 years since exhibits 436 and 437 were published?
A void in the research, there certainly have not been any articles that I'm aware of published in the last 10 years.
Okay.
Specifically looking at EDTA in bloodstains.
We talked earlier about how I asked, did you produce any other protocols that you used for testing EDTA? Why did you refuse to do that?
We have an attorney that's employed in our laboratory, and I was instructed not to turn over any other protocols other than the one that was used in this particular case, because according to the attorney, that's the only one that's relevant to this case.
Okay. So you had some internal attorney make the decision for you.
That's correct.
All right. We talked about, I think you agreed that the protocol was used in the OJ case was developed rather hurriedly, mid-trial, right?
It was, taking a procedure that we had in place, which is simply looking for chemicals, specific chemicals in a material, and we do this all the time at the FBI laboratory. Many cases, we are asked to look at stain. I'll keep it very simple, a stain, and determine if a specific chemical is in that stain. So in that general line of thought, we looked at our general procedure that we would use to identify an unknown chemical in a stain and applied that in the OJ case.
And
Now,
would you agree?
I'm sorry, what had to be done quickly to finish the answer is we had to look specifically for EDTA. So we had to set the instrument up so that it was targeting EDTA.
And in doing that quickly, in order to be used in the O.J. Simpson case, you didn't employ all of the 4, I forget what you called it, factors in validation?
Well,
Have I confused you or have I confused you? Do you know what I'm talking about?
I do.
Okay. You went through 4. What do you call those factors?
Well, there are different variables in the validation protocol.
And one of them you forgot today until you looked it up, right? Do you know what I'm talking about now?
Yes, I drew a blank. That was a carryover, but
Those are 4 experiments, I think, is what you called them, right?
yes, 4 different areas that we're evaluating on the procedure.
Detection limit, right?
Yes,
Interferences from normal blood,
that's correct.
matrix suppression,
Correct.
and carryover.
Yes.
And in fact, in the O.J. Simpson protocol that was used, as you went back and looked at it, you discovered, oops, there might have been some carryover that was affecting the results in that case.
That's not entirely accurate.
Well, okay, let me ask, why don't you explain? Didn't you, in fact, conclude that that carryover was a factor in some of the results that you were getting?
For this case or for...
For the O.J. Simpson protocol.
No, I didn't work on the O.J. Simpson case, so I didn't.
Well, you just studied it in order to develop this protocol, right?
No, I did not look at O.J. Simpson case, and I did not look for EDTA in the blood stain from that case.
But you looked at Exhibit 436.
Yes, I did.
And 436 expresses concerns about possible carryover effect in the protocol, right?
That's correct, it does.
And it's your testimony that you don't know that was alternately the FBI's explanation for the results that they got showing EDTA in the OJ case.
No, that's not my testimony. My testimony was that I didn't. You said when I looked at O.J. Simpson case, I didn't work on O.J. Simpson case.
Right. What I'm saying is your testimony today is that you don't know that scientists went back and looked after the OJ case, try and explain, hey, why are we getting these EDTA results, and concluded it was probably carryover.
Well, to be accurate about it, it was discovered in the middle of the trial when the evidence was being presented in the case. There was a break over the weekend, and the scientist that was doing the work came back to Washington and did some additional tests and realized that what he was seeing as a very small blip of EDTA in the blood stain was actually instrument carryover.
Okay.
From a previous sample showing up in the next sample. And he did experiments and he proved that to be the case. That was in the middle of the trial.
Okay.
Not for this paper.
Okay, but
this paper supported those findings that he had during that case.
And in that trial, your laboratory offered evidence based on a protocol that in the middle of the trial, your own scientists determined was flawed, right?
Could you repeat that?
In that trial, your laboratory, the FBI, offered a brand new protocol never used before, and in the middle of the trial, your own scientists discovered that it was flawed.
No, absolutely not. In the OJ trial, I don't know what we offered the protocol. I have no knowledge of that whatsoever. I don't believe that he said it was flawed. He was explaining the result. That doesn't mean that he did not identify EDTA or the lack of EDTA, but he did some additional validation studies in the middle of the trial.
Correct.
That's correct. And he reported that back to the court.
And so your laboratory offered evidence and opinions on a test that later validation studies in the middle of the trial proved to be not completely accurate because there was carryover. Isn't that right?
Again, I disagree.
Hold on a minute. This isn't a jury, this is me.
Okay.
And I think I've got the drift here.
All right.
So we can move on.
Well, there's another case that you were involved in which a protocol was developed rather hurriedly. Do you know which one I'm talking about already?
There are many cases we work on that protocols develop quickly.
Let's talk about the William Cybers case. Are you familiar with that one?
Yes, I am.
Cybers is capital SYBERS versus state. The citation is 841 Southern 2D 532 535 to 40, Florida, approximately 2003. Just giving the site for the judge and the record, okay?
Yes.
And this was a case in which a medical examiner was accused of having poisoned his wife with a certain chemical. And the accusation was that the charge arose about 9 years after she died, right?
That's correct.
And her body was exhumed and tested for this particular chemical, right?
Yes, it was.
And I'm sorry, but maybe you can pronounce it for me.
It's called succinylcholine. SUCCINYLMONOCHOLINE.
So this succinyl drug was tested by you. I'm sorry, some embalmed tissues and organs were tested by you.
Ultimately, they were tested by me, yes.
Based on a protocol, you had never tested for that particular drug before, had you?
No, I had not.
So you developed a protocol to test for that particular drug and that particular case, for that case.
At the request of a court, yes, we did.
Much like today, where you developed a test for a particular case.
Well, it was a little different. In that particular case, another laboratory had initially found this chemical in the remains of an alleged victim in that case, and
just to tell the judge which laboratory that was.
That was National Medical Services.
And let's tell the judge which doctor or scientist.
It was Dr. Kevin Ballard, who was a scientist on the particular case.
And what he did, and you then also tried to replicate with a slightly different test, right?
Well, it was significantly different.
But in both instances, Doc, you basically came to the same conclusion as Dr. Ballard, which was there was evidence that this woman had been poisoned with this drug. Isn't that right?
Not exactly what the conclusion I came to was we were asked to verify if this chemical, which I will just call SMC, was present in her specimen. And National Medical Services had found this chemical in every specimen they collected from her, from the heart to the kidney, the liver, the brain, and fat tissue. We were not able to confirm it in any of them except for 1 or 2 specimens. So we did confirm that this chemical was present in those specimens that were collected from an exhumed body.
Let me stop you there for a second, because you weren't able to find everything. You weren't able to find this chemical in as many tissues and fluids as Dr. Ballard had found, right?
That's correct.
And when you were challenged about that in court, you said, well, it's probably because he had a different detection limits than I did.
Exactly.
Which means that you can set up these tests in machines in a way that you set the threshold as to when something is considered detected and when it's not.
No. I mean, you could theoretically, but what that means in analytical chemistry, our instrumentation that we use, we have a pretty significant breakthrough about every 3 years in the quality of instrumentation. And what that equates to is how long we can go. So his instrument that he used in that particular test was very state-of-the-art instrumentation. In fact, we didn't even have one at the time and got one at a later date. But his instrument was much more sensitive to these things. It had nothing to do with any settings that we do in the laboratory. It's just the technology
Technology.
you are using at the time. And what he used, it was much more sensitive technique than what we had.
And when you developed whatever protocol you did use in that case, you did so knowing that there had never been a study of how this particular chemical works, reacts, breaks down in a body that's 9 years old, right?
No, I disagree again. There were studies, and I mean, you are calling up on memory from a number of years ago here, but there were studies that were published that dated back decades before that case, in which they did demonstrate the breakdown of the patient drug, parent drug, which is called succinylcholine.
Right. But none of them involved a test of what it would look like 9 years later when you exhumed the body, did it?
There would never be a study like that, so
Right.
yes.
And just like there is no study on what and how any EDTA would react or degrade or not degrade in a 9 or 11-year-old blood tube or blood vial, is there?
Well, again,
Simple question.
I'm sorry, but I disagree about that. There are
Oh, there's a study that describes the degradation of EDTA in a blood vial that is 9, or in your case, 11 years old.
I'm not aware of any studies. No.
Okay, that's fine. That was my question.
Okay.
Now, in that Cybers case, there was a conviction, right?
There was, yes.
A man was convicted of poisoning his wife, right?
That's correct.
After the conviction, it was reversed on appeal, right?
I believe it was, yes.
And after that, additional scientific tests were done that proved, although you thought the science was good at the time, subsequent tests proved them no longer to be accurate and correct. Isn't that right?
Not exactly, no.
I'm showing you Exhibit 439. Take a moment and look at them.
Okay.
This is a filing notice. It is entitled Notice to the Court.
That's correct.
State versus Williams Cybers, right?
Yes.
And you agree with me that this notice states, and it has the case number, that the notice states the purpose of this filing is to notify the court and the defendant that the recent scientific testing conducted by National Medical Services and the Federal Bureau of Investigations Laboratories has discovered that the findings specifically related to this defendant and the testimony of the experts from each of those laboratories, though believed to be correct at the time of the testimony, can no longer be relied upon. The findings of the presence of succinylcholine in the specimens tested are believed to be accurate and correct. However, the opinions that the succinylcholine proves to a scientific certainty the prior presence or injection of succinylcholine are not correct, right?
That's what it says, yes.
And that's what ultimately your own lab determined after you helped convict a man, right?
No.
Okay, let me ask, do you disagree with that finding?
I absolutely do.
Okay,
Again, we were asked to confirm the findings of the first lab, and we did in some of the specimens. And during the trial, one of the specimens that did not find succinylcholine, it was in actually the only specimen that the first lab never touched. Are you following me?
yeah,
So at that trial, I said of any specimens that are of relevance here because of the allegations was that the first lab had contaminated everything with this drug. I said the one that is of most relevance is the one that was never in the lab, and that's negative. Now, we were able to find saxillomonocholine in the tissues from the victims in the case, the Cybers case. And as you clearly said, the finding of the presence of saxillomonocholine in the specimens tested are believed to be accurate and correct, and I stand by that. What we did years later, again, we had new technology come into our laboratory, and in applying that new technology to the same method, we were going through another validation study to ensure that with this new instrument, we were still able to use this method. And in doing so, this more sensitive instrument was now picking up traces of this same chemical in specimens that were collected from people that had never been exposed to that drug. So this was
So you dug up bodies?
No, I did not dig up bodies.
Well, you looked at other dead bodies, tissues from other dead bodies, and you found the very same chemical, right?
We were provided specimens from Washington, D.C. medical examiner cases. And all of those cases, we had a very good history on what medications they may or may not have been given. And we used that information to come up with the end result of our laboratory was able to find traces of this particular chemical in a non-embalmed specimens that were collected from people that had never been given the parent drug, saxillonocolamine.
People that have never been poisoned.
Well, it's not a poison. It's a drug that you use clinically to paralyze the muscles of the body so that you can intubate you.
I understand that, sir.
People have to be on a respirator normally in order to live through that because the diaphragm gets paralyzed.
I understand that there's a legitimate reason for the drug, but what Mr. Cybers was charged with and what you testified on behalf of the state about was that the presence of that drug, a metabolite of that drug, actually proved that the drug itself had been given by Mr. Cybers.
That's right. And that was based on science, the knowledge of the science at the time.
Fine.
Of the testimony.
And the science changed a few years later, and you had to withdraw your findings in that case, your opinion in that case.
Yes, science always changes. That's part of it.
All right. Let's go to the Cooper case for a moment. You filed the affidavit that we saw earlier, right? In that case, right?
I'm sorry, I don't.
I may have taken...
I don't have a copy.
I'll bring that back to you in a minute. I'm not actually going to refer much to it, but my point is, in that case, you didn't actually do any testing.
Oh, that's correct, yes.
You were just brought in at the beginning to give an opinion about whether or not Mr. Ballard's tests were valid, testing procedure was valid.
Yeah. And again, I didn't even look at data that he generated on that case. I was asked to review his testimony and what he testified to as his approach, and then make a declaration as to whether or not that I felt that was an appropriate approach that he took.
Okay, so you disagreed with Mr. Ballard in that case?
With the approach that he took, yes.
Okay, but you agreed with Mr. Ballard in the Cybers case.
Well, I guess I agreed and disagreed.
Well, you confirmed some of his findings, didn't you?
Yeah.
And you rendered an opinion, like he did, that poor man, Mr. Cybers, had poisoned his wife 9 years earlier.
I agreed that we were able to find saxillomonocholine in the specimens that he collected from the alleged victim in that case.
And didn't you render an opinion that finding, to a reasonable degree of scientific certainty, allowed you to conclude that Mr. Cybers had injected the parent drug in his wife?
I never said in testimony, under oath, that Dr. Cybers injected his wife with saxillocholine.
But you did say that the presence of the drug the chemical you found, was consistent with someone having administered the parent drug to Mr. Cybers' wife before she died.
Yes, I believe that to be true.
Okay. And by the way, you interned with National Medical Services, SC, right?
Yes, I did, for about 3 months in the summer of 1988.
So you've worked quite a bit with Mr. Ballard.
I'm sorry, 1987.
Okay, so you've worked quite a bit with Mr. Ballard.
I don't believe he was employed with National Medical Services when I did my internship there.
All right. The Kevin Cooper case was a case similar to this in the sense that an allegation was made that a blood stain of his, the defendant's, was placed on some kind of crime scene evidence, right?
Yes, that's correct.
I'm showing you Exhibit 440. This is the EDTA testing order ultimately approved by the court in that case, right? Take a minute and look at it.
Okay.
Okay, and the test protocol developed there was sort of a compilation of testimony by a number of experts in front of this Judge Marilyn Huff, United States District Court, Southern District of California, right?
I haven't read this in detail, so I'm not sure.
Well, are you telling me then that when you looked for resources in February of 2007 to rely on or references to look at when you developed your own protocol from this case, that you did not review the protocol that was used in the Kevin Cooper case?
That's correct. I did not.
Instead, you relied just on the FBI's own protocol from 10 years earlier.
No, I relied upon my education and training, my experiences to make a decision as to what was the most appropriate approach to take in the request that we had in front of us for this particular case.
But in terms of protocols to detect EDTA in a bloodstain, you look only at the FBI's own protocol from 1997.
No, I did a literature research for published methods on EDTA, in particular for bloodstains, and the only two references I was able to find that were significant, in my opinion, were two that we talked about earlier that were exhibits
436 and 437,
Yes,
both written or published in 1997.
that's correct.
And so this order exhibit, what are we up to? Exhibit 440 is dated August of 2004, right?
Yes,
And you were aware of the Cooper case because you had provided an affidavit for it,
yes,
right?
yes.
But you're saying that when you developed the protocol for Mr. Avery, you did not consider the protocol has been developed ultimately with the court's approval in the Cooper case.
As far as I know, it was never a peer-reviewed published protocol. And as I stated earlier, my affidavit in this case said I disagreed with his approach. So that would imply I disagreed with the protocol he used. So I'm not sure why I would consult that as a reference to use in developing a protocol for ourselves.
Well, because did it ever occur to you that the court had taken your testimony or your affidavit or declaration as well as the defense declaration and then taken all of this testimony and had gone through all of this work for about a year to develop this testing protocol and you never looked at it?
No,
All right.
I wasn't aware of that.
Okay. And when you developed this protocol, you never came to this court and suggested, hey, this is how we think we're going to do it. Do you think this is going to be a valid approach in order to allow the evidence or the opinions to be admissible?
No, we never do that, sir.
You are the FBI. You do things your own way.
No, it's our job to independently develop a procedure and put it through the required steps of validation.
Let's talk a little.
As defined by our accrediting body.
Okay.
And then to present that in front of the court, who is the gatekeeper, as you know, as to whether or not it should be allowed in.
Okay. The exhibit in front of you describes a protocol that's done under what's called double-blind procedure. Are you familiar with double-blind?
I am, yes.
Your Honor, I would just like to make a clarification here. I understand this to be an EDTA testing order. Could counsel lay a foundation that this is a protocol? Seems to me this talks about the order of testing. Who gets it first? What do they get? But to refer to this as a protocol, I would like a bit more foundation.
All right. Well, I'll accept the amendment of this, not as a protocol, but as a testing order prepared by a court in the Cooper case. All right?
All right, but again, I have never read this, so
Okay.
I feel like I should take time to read it if you're going to question me about any of the science and the specific steps in it.
Okay. Well, rather than do that, let's just move on to this issue of double blind testing. What is double blind testing?
Double blind testing is essentially a proficiency test or competency test that's done so the person taking the test doesn't know the results while they're taking it, doesn't know the right answer, and also the person administering the test doesn't know the right answer. It's an independent system.
And what that's in part designed to do is get rid of any kind of potential bias that the tester may have, right?
That's true.
That if the tester thinks he's being asked to find a particular chemical in a particular sample, there may be some examiner bias potential.
Yeah, that's true.
And so double blind means that they are given these samples, they don't know whether it's a control, they don't know whether it's a swab from the RAV4, they don't know what it is, right?
That's true.
They just test it for the presence of EDTA.
That's right.
You didn't do that in this case, did you?
Yeah, yes, we did.
You did a double blind testing?
We did blind testing, not double.
And blind testing, and blind being what?
Did blind testing, I'm sorry.
Blind being in what manner?
Well, it was before we analyzed the evidence in this case. I had one of my employees prepare 10 swabs, and some of those swabs had EDTA blood on them and some did not. And then myself and one other scientist were randomly assigned those 5 swabs.
Are you talking about the validation test?
No, sir, I'm talking about a competency test, which was in that binder that we sent to you.
Well, I'm directing you to the test in this case on the evidence.
Well, you asked me if we did any blind testing on this case, and my answer is yes, we did. And I was explaining that.
Go ahead then.
So we did not know the answers up front. We just knew that the swabs had blood on them and that they either had EDTA on them or they did not. Some did, some didn't. 2 different scientists were assigned, 5 and 5. And we ran the tests. We reported those results back to the independent person that wasn't even involved in giving the test in the first place. The independent person was handed a sealed envelope that had the results in it, the right answers. After we gave our answers to her, she then graded our results and prepared a memo back to our training files to show that we successfully identified correctly 10 out of 10 of those swabs.
Let's clarify for the court. Those swabs and samples you're talking about were not the RAV4 swabs or the blood vial in Mr. Avery's case.
No, there was no.
Okay, so when you tested the evidence in this case, the blood swabs, the swabs from the vehicle, the control swabs from the vehicle, and the blood vial that was sent to you, those tests were not done in any blind fashion.
Well, no. I mean, we knew what we received. We had to check it in. We had to follow our standard forensic practices of looking through this evidence, documenting these things.
Sure.
And then we had to apply it to the protocol.
Right.
So I don't believe you can do it blindly.
Well, how many chemists do you have working for you?
I have a number of chemists, but they are not all qualified to do this type of examination.
How many qualified chemists do you have to do this exam?
3, counting myself.
Okay. You could have had yourself or one of them go through, log in the evidence, identify it, give it a Q number or whatever, right?
Yes.
And then you could have had another chemist test it who didn't know what those numbers and designations meant. Apply to.
Yes, that could have happened. Yes.
But you didn't.
No, that was, we don't normally do that.
You had the same chemist who tagged and booked or the items also do the test?
That's correct.
And just so we're clear, you didn't do the tests in this case.
No, I did not.
Mr. Brewer, what's his name?
Jason Brewer.
Jason Brewer. Brewer.
Dr. Jason Brewer.
Dr. Brewer. Why isn't Dr. Brewer here?
Because he's, in this case, he served the role of a laboratory technician.
So when Mr. Brewer was doing the test, when he was running a test to see if there was EDTA in an item Q46, he knew that item Q46 was a swab from the vehicle.
Yes, he did.
Okay. Now, the question of whether or not you are seeing a particular chemical in one of these LCMSS tests requires some subjective interpretation by the examiner.
Well, as the protocol indicates, there are a number of criteria that must be met in order to make the call that it is a positive finding, that it's truly identified. So if all those criteria are met, that's clearly there. And if they are not met, then we determine that it's negative.
Well, talking about these mass spectrum instruments, there are limitations on what they can tell you, right?
Can you be more clear on that?
Well, you can't just run a sample, then open the door, put the sample in, close the door, thing beeps a bunch of times, and spits out a result.
Only on CSI.
All right. Not certainly in real life.
Not in real life, but it is, the mass spectrometer is considered to be the gold standard of instrumentation that's used in analytical chemistry. So,
Sure, but even it has limitations.
well, yes, everything has a limitation. That's right.
Okay.
And that's why we put into our protocol this SOP. We write what those limitations are.
All right. But you also have what's called guidelines for comparison of mass spectra.
That's correct.
And that was issued June 21st of 2006.
That's correct.
You're familiar with that?
Oh, yes, I am.
And it talks about basically what kind of guidelines you're supposed to follow before you make a call that something is or isn't present, right?
That's exactly right.
Okay. And do you agree with this statement that the definition of what makes any given ion characteristic, quote unquote, of a particular chemical structure is somewhat nebulous?
Can I see where you're referring to?
Sure. Sure. This would be on guideline 9.3.
Okay, but it does say that, but you have to put it in context
I understand that.
with what's around it.
Sure. But what it's telling you is that something called diagnostic ions, right?
Yes,
And that's something that, you put these things in and it spits out, the computer spits out these graphs and spikes and whatnot. I can show you that later, but right? I'm simplifying, but
very much so, but yes.
okay. And what this is telling you is that there does not appear to be any universally accepted standard in the field. This means that good and consistent judgment by the examiner is essential.
That's true.
Okay. And it's also telling you, though, that you have to be careful about the interpretations of the results, even with this wonderful instrument, LCMC, or just the MS part.
That's exactly right. You have to have the experience and training in order to interpret the data.
Did you, by the way, approve these guidelines? I believe you did.
Yes, I did.
Would you take a minute and look at limitations item 14 in that list of guidelines? Okay.
Yeah, absolutely.
Did you write this?
No, I did not.
You just signed off on it.
I reviewed it and signed off on it.
Maybe we'll mark this. Well, I'll mark it and then I'll get a copy that's not highlighted over lunch. Just identify for the record now this exhibit 441.
All right.
That's entitled what?
It's entitled Guidelines for Comparison of Mass Spectra.
Okay. And this is a document that the FBI laboratory chemistry unit follows.
Specifically for the toxicology subunit of the chemistry unit.
Okay. And so would you agree or disagree with this statement? The mere fact that an unknown mass spectrum matches well to the spectrum of a known standard will rarely, by itself, be sufficient grounds to claim the presence of that compound in the question sample.
Absolutely, that's a correct statement.
And quote, similarly, the fact that an unknown mass spectrum fails to match that of a known standard will generally, not by itself, constitute grounds for concluding that the compound is not present in the questioned specimen.
That's right. In simple English, what that is saying is you have to consider all the data that you have generated in order to make a call that something is there or not there. You can't just pick the data that matches your hypothesis. You have to take the totality of the information.
Sure.
And apply it in your interpretation.
So it's not just what comes out of these graphs, you have to interpret them.
Exactly.
I think, Mr. Putin, if you are moving on to another line of questioning, it might be a good time to take a lunch break.
Sure.
Are you done with the exhibit 441?
Actually, I am. This would be a good time to break.
All right, let's report back at 1 then.
Before Mr. Buting continues, could I just make one observation for the court about the admissibility hearing?
Sure.
At one point, I believe Mr. Buting stated that he is not challenging or questioning whether the LC-MS test can test for EDTA in blood with this instrument.
No, that's not what I said.
Even if not challenging that, I would think that the admissibility, everything so far he's been questioning on, really goes to weight of evidence as opposed to admissibility. And if he's not going to challenge the underlying scientific principles of LC-MS, aren't we over with this hearing?
We most certainly are not, because it's the application of this to this particular instrument, which may be perfectly acceptable and reliable in the field, but it's the application of this instrument to this test to its ability to determine EDTA in a bloodstain that's being challenged here.
One of the elements that the court has to address in determining whether expert testimony is admissible is whether the evidence will assist the trier of fact in determining an issue of fact. I'm assuming that's what
Yes.
Mr. Putin's line of questioning is directed at, so I'm going to allow it.
The court's microphone is a little... Sometimes we aren't getting it at all, and sometimes it seems soft.
Alright, unfortunately it's glued to the desk, so I do my best, thank you. Mr. Putin, you may proceed.
Thank you very much. All right, Mr. LEBEAU, let me just go back to one thing for a moment. The FBI's attorney, his refusal to produce the prior protocols that your lab has used for EDTA tests, okay?
That's correct. I was instructed that the only protocol to turn over for this case, based on the letter that was sent to our laboratory, was the protocol that we applied for this particular case.
Well, would you agree that if we looked at the old protocols that you used and we saw any differences between those protocols and the one that you devised, we could ask you about those differences, right? If we had those old protocols.
Potentially, if there were significant differences, you could ask.
Okay. And we could ask about what the reasons were for you to make any changes between what you have got now and what you had previously, right?
Yes.
And we could ask about what studies you've done or relied on in order to make those changes in protocol, this protocol from any prior ones.
Yes.
And if we saw that there were any internal critiques or those prior protocols, we could learn even more about possible weaknesses within this protocol.
Well, there are no records of internal critiques about the former protocol.
And why are there not any internal critiques about that?
There was no reason to critique it.
Then why didn't you use it in this case?
Well, as I indicated earlier today, we moved our laboratory from Washington, D.C. to Quantico, Virginia. And in doing so, we acquired a number of new instrumentation that we did not have when we were in Washington, D.C.
Well,
As part of that move, we had to, in essence, revalidate or at least reconfirm that every protocol that we moved with us was actually working the same way in the new facility. Now, as I had
but
also indicated earlier, we had not had any request to do this particular analysis since we worked in the O.J. Simpson case. Our laboratory moved in 2003. So over that course of period in 2003, we essentially did not take with us that old protocol. I mean, it's an electronic document, so it's not that we didn't have it available, but it's something that we chose not to bring online in the new laboratory because we weren't getting requests to perform this analysis.
my point is, you do have it. You're just not turning it over because your attorneys doesn't want you to.
I honestly do not know that we have a protocol in this format, as I turned over for this case for what was done in the O.J. Simpson case. That was under a completely different quality assurance programs, and at the time, we weren't even required to have written protocols like this. There was a protocol in existence, as I said earlier, that would allow you to identify chemical in a stain, not specifically EDTA in a blood stain.
Well, are you saying that you think scientists from your lab came into the O.J. Simpson case with all the publicity in national television and presented results of testing for EDTA in a blood stain and didn't have a written protocol?
I have no idea if they did or did not. I'm sure there was a written protocol, but at the time of the OJ case, this is in the mid 90s, completely different set of rules for laboratories in the mid 90s.
Sure.
And at that time, it was acceptable by the standards at the time. It was acceptable to write your protocol just in your notes for that particular case. As long as you wrote what you did, that was fine. So that would be a document that's generated like this today.
All right.
So it could simply be the notes from the O.J. Simpson case that would have the protocol.
But if we had those notes, we would be able to look at the differences between that protocol and yours today.
Yes, if you had a protocol from the O.J. Simpson.
Just so we're clear, that machine, their instrument, even though you may have new versions, the very same test that you used in the OJ case that also involved LC-MS-MS, did it not? Tandem mass?
I don't know. I didn't review the O.J. Simpson case. I didn't do the original work in the O.J. Simpson case.
Okay, but you have read the published exhibit 436, right?
Yes, I have.
And that was done very shortly after the OJ case, right?
Yes, it was.
And the method that's used in that report involves LC-MS-MS, does it not?
Yes, it does.
Okay, so maybe different instrument, but the whole idea of being able to do these with one of those combination liquid chromatography and tandem mass spectrometry, that part is the same. You are using the idea of using that instrumentation is the same.
That's correct.
It's other things that we can tell that have changed because we don't have the protocol, right?
Yes, you can distinguish if there's any differences unless you had probably the case file, the actual case notes from the O.J. Simpson case. That's where you would be able to differentiate between what was done in that case and what I did in this case.
All right. Now, going through this February 15th, 2001 protocol for a moment, that's 434.
Yes.
Are there any internal critiques or comments about that protocol or from the approval process?
If there are, they're in the packet that I provided you.
Who approved that protocol?
Approved it in what manner? We have 3 levels of approval.
Right.
On insurance.
And the ultimate approval for a new protocol is the unit chief, right?
Well, it's a combination of myself as the unit chief and the quality assurance unit chief who oversees quality for the whole laboratory.
Sure. But were you involved in the actual development of this protocol?
As a supervisor, I was, yes.
And then you were also there in the position where you also had to sign off on it.
Yes. And it's for every protocol in our unit. As the supervisor, I oversee the development of the protocol and then assure that all the steps have been met for a quality program. And then a second check that is our quality assurance unit chief that does the same thing.
So, but in other cases, let's say if someone is developing a protocol of a test, some other chemical, in a routine, not a hurried manner, not a specific trial date, and all that, he may not be involved in the development of that protocol at all, right?
Well, it depends on who case is assigned to. If it's assigned to another examiner in our unit, then I wouldn't be as heavily involved with it. But in this case, it was assigned to myself, and I had more insight into the development of the method and the validation.
But in those cases where you are not involved, where it's not assigned to you, someone else develops the protocol first, right?
Yes,
Without your involvement.
they may come to me for guidance.
Okay.
I'm their supervisor, so.
But then it comes to you after someone else, another examiner completes it. Then it goes to you for approval at the unit level, the unit chief level.
Well, I wish it was quite simple, that simple. Actually, there's when a method is developed, we have the validation steps that have to be drawn to, be adhered to. As part of the validation, there is a checklist that is completed. That checklist helps the scientists doing the validation assure that they are completing each of the required steps of the validation. That validation study is reviewed by an independent scientist that had nothing to do with the validation, and then I do a review of that on top of it. That's for every protocol that's issued into in our unit.
Right.
In this particular case, because I was involved in the validation, I didn't do the validation review. I assigned that to another employee to do the validation review, and she reviewed all of the validation data and signed that she agreed with the work that was done there.
Right. But then it gets to the next level of unit chief approval, and you're basically approving yourself. You're approving your own protocol at that level in this case.
Well, I suppose technically, yes.
I'm just trying to distinguish how, in some cases, when it gets to the unit level, the unit chief approval level, it really is another independent review by you who wasn't involved in the development.
Yes.
But this case worked differently because it was assigned to you to begin with.
Slightly different.
Okay. All right. Let me talk about some of the assumptions that I think you're making as you do this test. Okay. I call them assumptions. You may disagree. But for instance, in doing this test where you're trying to see if there is EDTA in a blood stain that may have come from a blood vial that is now 11 years old, you make an assumption that the EDTA that was originally in that blood tube has not degraded in the 11 years to the point where it's not detectable, right?
I did not make that assumption, no.
Okay. Well, if in fact the EDTA had degraded in 11 years, then it wouldn't be detected, would it? Simple question.
If the EDTA had degraded, then it would not completely degraded, I should add, to 0, then it would not be detectable.
Not really completely to 0, just to the point where it's below your limit of detection, right?
That would be a very significant reduction in EDTA because the standard tube has
But sir,
approximately 1,000 to 2,000 parts
sir,
per million of EDTA.
please.
I'm sorry.
Judge, I would direct the witness.
I'm sorry, I didn't get his answer.
I said the standard tube has approximately 1,000 to 2,000 parts per million of EDTA in it.
Thank you.
All right, sir, just follow with me. We'll get to that, all right? But the first step is this. Would you agree with me if the EDTA has degraded not to 0, but to a point where it's below your limit of detection, then your test would not show it, right?
Well, it would have to degrade to a level below 13 parts per million from that
Whatever
original.
whatever it is, whatever your limit is, it could still be there, but not be detectable.
To below 13 parts per million.
Right. And so when you say that, when you express an opinion that there is no EDTA in those stains, I'm sorry, let me rephrase that. When you express an opinion that the blood in those stains in the Toyota could not have come from the blood vial, you're making an assumption that the EDTA that was originally in that tube 11 years ago was not degraded to the point where it's not being detected on those stains anymore, right?
No, we tested the tube of blood and determined that it did have EDTA in it at high amounts.
You quantitated it?
Did not quantitate it, but I compared it directly to a fresh tube of EDTA blood, and the results for the same amount of blood analyzed gave very similar results.
Wait a minute. Are you telling us now that you quantitated the level of EDTA in that blood vial? Yes or no?
No, I said we took the same amount of blood from a fresh tube of EDTA blood compared to the blood sample from Mr. Avery. Same amount of blood on the instrument gave the same comparable response.
Okay, let's talk about that.
That would indicate.
Let's talk about that.
I'm sorry, I didn't finish. That would indicate to me that there was no significant degradation of EDTA in that tube.
Are you testifying then that your mass spec test quantitates the level of EDTA?
It's certainly capable of doing that, yes.
Did you do that here?
No.
All right. Now, if what you found when you do this test is that, we'll get to that in a minute, but whatever your mass spec printout graphs show were some peaks that would be consistent with EDTA, right? In the blood vial.
Which blood vial?
The blood vial.
The blood vial from Mr. Avery?
Yes.
It had peaks in it that were identified unequivocally as being EDTA.
And those peaks don't tell you whether there is 1,500 milligrams per liter or 13 million grams per liter, do they?
Oh, they do. They give you an idea of how much is there, and we do that.
So what's the idea, sir? Where is it in your reports that you have any conclusion drawn about what the quantity of EDTA is in that 11-year-old blood vial? Show me. You've got it right in front of you.
In my report?
Show me where, anywhere in your reports, your stack of 6-inch lab sheets, show me where you express an opinion that there is a particular quantity of EDTA in the blood vial.
No, I did not do a quantitative analysis, but the response on the instrument does allow an experienced chemist to assess if there's a, you can tell from the response if you have 50% of what you're comparing to, and you can tell if you have 10%.
Oh, yes.
Because the instrument gives a certain peak size.
Show me.
That it's not.
Show the judge.
It's not in the report. It's in the data.
Show the judge in the data.
Okay, it will take me 1 minute.
And while you're doing that, show the judge in your report where you say anything about the quantity of the EDTA that you found in that 11-year-old blood vial.
Can I approach?
Can I see them, please? Okay, what you're pulling out are all positive controls that you did, right?
That's correct.
Show me a test that you ran not on a control extract, but on the Q49, whether it's a spot, 2 microliters, 1 microliter, whatever.
You're holding it in your hand. The Q49 is positive control B, was the actual tube of blood from Mr. Avery that we prepared a second control to for this very reason, to assess the EDTA in that tube had not significantly degraded.
Well, where is the sample of Q49? Not the positive control that you ran through. Where's the actual evidence sample?
This is it.
That's it?
Yes.
You ran no separate Q49?
Well, we also did to another detection limit study with the specimen Q49, where we took 1 microliter drop and 2 microliter drop of that same blood from the tube from Mr. Avery, and we analyzed that with this protocol as well.
Okay.
But that was a detection limit study.
Right.
To verify that our instrument was capable again to see that level of EDTA.
And that's important because if your detection level isn't right, it may be there and you're just not seeing it.
Your Honor, at this point, could we back up and could you mark the exhibits that Dr. LEBEAU pointed out to you and show you where the EDTA testing was done? And why don't we show those on the Elmo?
All right.
And just basically go through what you just went through before with Dr. LEBEAU.
Just to clarify a couple of things for the court. I have, which was attached to the state's motion, a copy of the report of the examination. I don't believe I have got the document that's being referred to here. Do I take it? Was a copy of the document that's being referred to previously provided to the defence?
Yes.
On Friday to me without a chemist.
Okay, and can a copy of the entire document be marked as an exhibit? Is there a copy of the document available? Or is that entire thing the document?
That's it.
Yes. This is the discovery which was provided by the FBI, and what Mr. Buting is talking about to Dr. LEBEAU about are a couple of pages from this discovery package.
Alright, and so you are asking the pages to be identified as an exhibit?
The ones that he just talked to Dr. LEBEAU about on the stand, where Dr. LEBEAU was pointing out the levels of EDTA. I think those should be marked and actually shown on the Elmo so that everyone knows exactly what we're talking about here.
I think Mr. Butin actually was about to show them on the ELMO.
Yeah, I will. I'm going to show, maybe we should mark the whole thing. The state can get us another copy, and at the end of this hearing, for any possible appeal record, we'll have a whole copy.
Any objection from the state?
No, Your Honor. We can have another copy made.
Alright, if that's going to occur, then I think as long as we identify what you are looking at by page number or some other fashion, when the entire exhibit is received, we should be able to identify the pages that are being referenced.
All right, I'm going to show you this first page, which at the top, I'm going to show you this overall page first so you can see. This graph on the right, this graph on the right side that you're referring to, where this is a peak that you're saying is well, actually, this is, can you see it? See the top?
No, I can't.
All right. The date is February 16 of 07.
That's correct.
The time is 4 a.m.
That's correct.
Somebody is doing this test at 4 a.m. in the morning?
No, an instrument, a robot in the lab is doing it.
Oh, really? So there's nobody there to monitor it at all?
No, it's set up as an auto sampler. It runs itself once you put together a sequence list. It shoots one sample. When that sample is finished, the next sample is injected, and so on and so on.
And it does that all night long?
It did in this case, yes.
Okay, on a bunch of different whatever samples are being tested, could be more than one case?
No, just this case. It was the only one tested on this instrument at the time.
Okay, it says positive control A MALEDTA extract.
Yes.
Is that you?
Yes, it is.
Your own blood?
Yes, it is.
So you are the lab volunteer who gave his blood?
Yes, I was.
Okay. And then what was put into the tube with EDTA?
It was, yes, in a purple top tube.
Mixed up,
Yes.
then extracted, and
For clarification, 5 microliters of that blood were put onto a cotton tip applicator, and then it was carried through the procedure that's already in.
okay.
It's a court exhibit.
And when you get these, it goes through believe me, I'm not an expert, but as I understand it, it goes through this machine and it's bombarded with some kind of electrical charge so that ions are knocked free from the molecule.
Well, first, it separates the mixture of all the chemicals that are in the blood into their individual chemicals. And they came out at different times. So it's probably easier if you look at the other side of the graph first. And if is there a laser pointer I could use, please? Is it possible to put that whole side of that page up on one at a time?
Sure.
Okay.
Is that good enough?
Yes, thank you. So what we're looking at then is this is one peak, 2 peaks. There are different mass spec experiments that are going on that are monitoring the time that it takes for that from that injection till that EDTA peak comes out, and this is the EDTA peak right here. So again, now if you don't mind, just zooming in a little bit.
That's your blood on that graph, the top one.
Yes, it is.
All right.
Okay. So it took 0.89 minutes, roughly 0.9 minutes, for the EDTA to be injected and then come out of the LC to the mass spectrometer. That's what's indicating. So that is an EDTA peak there. And on the right side of the graph is the chemical fingerprint I told you about earlier that the mass spec gives us.
That's this one. 160 is at the top.
Yes.
These are the ions you're looking for. For 3 ions, right?
That's right. Plus the parent ion 243, that's 293, I'm sorry. That's the weight of EDTA. And then these 247, the 163, and the 132, those are, I'm sorry, the 160 and the 132 are the fragments of EDTA. And a simple way to think of this, if you took a sheet of glass and we could hit it with a hammer and every time hit it exactly in the same place at the same amount of energy, that the sheet of glass is going to fracture the same way. And if we could catalog those fragments into a database and catalog it based on a different type of glass, we could say, okay, this is that type of glass based on that fermentation pattern. That's what a mass spec does with a chemical. It fragments into a consistent fermentation pattern that serves as a fingerprint. This is the fingerprint for EDTA that you see up there. If you zoom out a little bit, you can get the whole picture. And what's important is that not just that you have those 4 fragments there, but look at the relative ratio of those fragments. The most abundant is the 160 at the very top. That's what's called the base peak.
Right.
And then we have in the ballpark of around 15 to 20%, the 132 and the 247. And below 10%, we have 293, which is that's what it originated as, the full EDTA without being fragmented. Okay, so that is for my blood that was put in EDTA tube, mixed up. 5 microliters of my blood were put onto a cotton tip swab and run through the application. Now, if you go back to the top of that particular graph, on the right side here, this is via signal. This is how much of a signal it gave. That's 1.3 times 10 to the 5th. That's the amount, in essence, that the instrument is reading. It's not, I'm not telling you a quantity, I'm not putting a number on it, but it's giving, the more that's there, the higher the peak is going to go, the higher that number will go. So if I had, in essence, twice as much EDTA in that sample, I would have 2.6 times 10 to the 5th in that category. If I had a tenth of the amount of EDTA in that sample, I would have 1.3 times 10 to the 4th.
Okay.
That's how I'm able to give you an approximate amount.
Okay.
Without doing a quantitative analysis.
Well, first of all, let me just make clear, you don't express any opinion in your report about the quantity of EDTA in that tube, do you?
No, I don't.
Okay. Now, you say this is the signature for EDTA, that 160 is way up in the 100, and the 132 and 247 are about sort of even amounts down here at 1500 or something, right?
That is the mass spectrum that we obtain on our instrument in doing this experiment, which is called positive mode electrospray ionization, LCMS-MS.
I'm going to show you one that is exactly the same time, 2/16/07, 402/32.
Mm-hmm.
Positive control, MAL, that's your initials.
Yes, it is.
EDA extract.
Yes.
EDTA extract, excuse
Yes.
me. Thank you. Got strong 160.
Yes.
And down here, the 247 is only about half as intense as the 132, right?
Could you go back to the top? I want to make sure I'm looking at the same one.
And by the way, there's quite a few other little small peaks in the bottom of this one, right?
Yes.
175, 195. What do those mean?
Well, those are background ions. I mean, it's not always real clean.
Contamination.
No, not contamination at all. The instrument has noise to it, and what that means essentially is there's always going to be some signal in that instrument that's going to be recorded. So that's all we're seeing there, and we can display that by subtracting out the noise. We can display it including the noise, and what you're looking at is the same. Again, I didn't see what the top number was.
I'll get to that. I'll go back. Don't worry. I will go back, but I want to get back to this.
Well, I'm sorry you asked me about that, and I wanted to verify if
I will get to it, sir.
it was the same sample.
I'm just asking you now, do you see any noise in this first one we looked at? Do you see any other ions at the bottom of this? You said the machine always has background noise.
It does, yes. And as I said, there are different ways to display it so that you can display it without the noise.
Okay.
And I can tell you that by looking at the top of the sheet that you don't want to show me, I guess.
The top, is that what you want?
Yes, okay. You switch to the other one now.
This is the one you wanted to see.
Yes, this is the mass spectrum across the whole peak from 0.81 to 0.95 minutes. So that would include.
I'm sorry, could you repeat that and slow down just a little bit? Thank you.
I'm sorry. This is the mass spectrum in this column here of this whole peak, essentially from this part of the peak where it's just starting over to that side. So it's taking the advantage of the signal across the entire peak, which is taking, roughly a tenth of a minute or so to completely come out.
And so it gives you a slightly different spectrum where the 247 ion is only half as intense as the 132 ion.
That's exactly right.
And that's actually more what it should be, isn't it?
Well, yes, that's more what it should be. You're right. And that's why I use that particular display that you just had up to create this chart here, which is, as I indicated earlier, Your Honor, we have in our protocol a section entitled Decision Criteria. And this is a section that is to ensure that we have a consistent interpretation of the data so that scientist A and scientist B are going to look at the same data and come to the same conclusion. And with that in mind, we have employed criteria that must be met in order to call something positive based on mass spectral data. And that's what you see here. This is this is applying that.
Before we turn to this,
yes.
So what you're saying is when you get these two different looking spectrums of your own blood, one that has the 132 ion, the same signal response as the 247, you make some subjective conclusion that the instrument is not completely right that it's really supposed to be more like the second one I showed you, where there's actually a difference, a ratio between the 132 and the 247.
Again, you failed to go back and show me the header on that one, which was what I was looking to do.
I did show you that.
No, I'm sorry.
Do you want to see it again?
You did not. Yeah, it's the one that you're saying is clean. You failed to show me the header on that. But
well, I can take a look at it. I believe we looked at it in the beginning, same date, same time.
as you will notice, it says right there, retention time is 0.91. So that's, instead of it being an average, Your Honor, across the whole peak, it is simply looking at what is the mass spectrum right at 0.91. This is the initial assessment of the data right here, what you're looking at. The initial assessment where we're going through and we're trying to make an initial assessment as to whether or not there is something potentially there to go back and take a closer look at. And in this case, it's a positive control. It seems obvious that there are ions on there that are characteristic of EDTA. So then we went back and looked at the data and displayed it under the proper conditions that allowed us then to assess it for the ion ratios, the requirement that it's in our actual SOP.
But in this,
and that's why there's a separate printout.
All right, but wait a second. So the other one is an average. That's fine. In this one, you will agree with me that the signature, the spectrum signature, is not exactly like the other one because you're getting an equal strength response from the 132 ion and the 247 ion.
And that's why we average across the whole peak, because the instrument is in each millisecond. It's hitting this chemical and breaking it up. So you're going to get some fluctuation in the signal, and we average across the whole peak because that's a more characteristic of the signal. It really wouldn't be fair to anyone to base it on just looking at one point in time when the peak is composed of signals across about 15.15 seconds.
Sure. So a few minutes ago, when we looked at this and you told the judge that this was the spectrum, this was the signature for EDTA, you want to correct that now?
No, I don't. I mean, that is the typical mass spectrum that you should expect to find, mainly looking at the fact that the base peak, which is the largest peak, is 160, and you have fragments of 132 and 247 with a small amount of 293 present. That's what we're looking for with that initial assessment, as to make a determination whether or not we should look at it closer for the presence of EDTA.
All right. Well, let's look at this other exhibit, which says at the top, tandem mass spectrum, positive ESI mode. Okay, this is a chart now. And on the left, it has got positive control A, positive control B at the top. Then it has numbers that show the response.
That's right.
And 160 in this column right here is about 91,000, right?
Yes.
132 is like much, much less, 13,000. 247 is about half of that.
Yes.
And that's what it's supposed to be, isn't it? They're not supposed to be even or.
Well, there again, if you look at the protocol I have provided, it does talk about this. There's an acceptance range of those fragments, and generally it's within. It depends on the type of mass spectrometry we're doing. It depends if we are doing this type of mass spec. But there are predefined acceptance criteria for the mass spectral data in order to get that consistent interpretation. What you're looking at here is the actual abundance of each of those ions plugged into a spreadsheet that we generated in our laboratory to automatically apply the rules that we have in our protocol to the data, as if the jury will ever understand this.
I understand, sir. Thank you. All right.
So that, you don't have to sit there and manually do the calculations every time. You plug it into the thing and it will tell you if the criteria is met in order to call it a pass or a fail. So what you have for...
You review that too, right? It's not just...
Oh, of course.
Pass, fail by the computer.
Of course, yeah, absolutely. It's reviewed manually as well. But I'm just saying so that somebody doesn't have to sit down with a calculator and apply the calculations each time. But you can also tell, 15% and 14% are very close to one another. 8% and 10% are very close to one another.
Sure.
Where we have one that fails, though, is the next one down, if you would.
Yeah. Now let's
41% is nowhere.
wait. Let's just.
Hold it. I want both of you to stop for a second.
Okay.
This is cross-examination, so don't go into explanations that he doesn't ask for.
Okay, yes, Your Honor.
Your attorneys will have a chance to redirect to follow up, if they wish, and let's each of you try not to talk over one another.
All right.
Mr. Bruton, if you think he is not being responsive, then let me know and I will rule on it, okay?
All right. Thank you, Your Honor. I'm sorry.
Go ahead.
Could we mark this as an exhibit if possible?
Sure. Do you want to mark the whole book as like 442 and then have 442A, B, C, something like that?
Well, I'm really interested in.
Let's give this exhibit the next sequential number. And when the book comes in, we'll give the book a number.
Okay. This is 442, right? This is sort of a chart that summarizes what the results on this particular test were, right? Is that fair?
Could you say that again?
This is a chart that summarizes or prints out what the results were on this one particular test or series of tests, whatever it is.
Yeah, that's a series of tests.
Okay. All right. Now, Q49 is the blood vial of Mr. Avery's blood, right?
Yes, it is.
And you know your analyst knew that and you know that your analyst knew that when he was doing the test too, right?
Yes, he did.
Okay, this particular one is Q49, limit of detection 1 microliter.
That's correct.
And then down below is Q49, limit of detection 2 microliters, right?
That's correct.
And when you're doing what you're doing here, when you test down to only 1 microliter, you find that this is the control. And if we notice, these are the same all the way down. 3 times the positive control A is the same, right?
That's correct.
Same number, same strength, same ratio, everything to the decimal point, right?
Yes.
But 1 microliter, this one is showing no 132 and a 247 shows up at like 1800.
That's correct.
So that's considered a fail.
By the criteria I was describing, yes, that was ruled as a fail. It does not meet the criteria to call it positive.
Okay.
For that 1 microliter drop using that particular technique.
So in that particular technique, that was what, too small of a sample then?
Yeah, it's right. As I explained earlier, that's right at our detection limit as we found in our validation study.
So when you said it was valid to that 1 microliter, it's not exactly to that 1 microliter because here it failed at 1 microliter, right?
Well, in this particular sample, yes. And in this particular analysis, yes, that failed.
Okay, but then when you increased it a little bit to 2 microliters, we did get a pass because the ratios between 160 and 132, then the 247, are about within tolerance, right?
That's right.
But we know.
I'm sorry. To be clear, but I ultimately ruled that negative as well.
That's right. That's what I want to show right now because is that your handwriting and your signature on those?
Yes, it is. Well, I'm sorry, the top 2 are not my handwriting. That's the reviewer that reviewed the data before the report went out.
Okay, looks the same to me, but anyway, the handwriting that says extra fragment ruled ND with a circle on it, that's yours?
Yes, it is.
And despite what this chart says, and despite what that machine says, when you look at the actual graphs, there are too many extra peaks to make a call on that one.
Yeah, it was. It wasn't as clean as I would like it to be to feel comfortable making that call.
Okay, and this is at 2 microliters, right?
That's correct.
You went back you want to go back a few pages deeper into your book. There's a sequence that's run at different times, actually. Here's one that is run at 4:35 in the morning on the 16th of February, right? Would you agree with me? I will move it over so you can see what we're looking at. We're looking at a positive control B, which you say is an extract from the tube of blood.
Would you mind zooming out so I can see the whole picture a minute?
Sure.
All right, I'm sorry, but I believe you took that from me earlier, my copy of that.
You're right, I did. We'll use yours and we'll mark this. Now, we just saw in that early example, we saw the signature for EDTA and the ratios. And this one is, again, it's very close in time. It's 4:35 in the morning on February 16th.
That's correct.
It has the 160 peak there, which is always set up. You set that up at 100, right?
The instrument normalizes itself, so the most abound peak is set to 100 and everything has been put relative to that.
Okay, sure. So this, if it detects 160, it's always going to be up there at 100 because it's adjusting it accordingly.
Not exactly. It has 160 has to be the most abundant.
Oh, okay.
For it to be set at 100.
Okay. Now, as we look down at this, the bottom of this graph, this is Mr. Avery's blood. You can see that the 132 ion is coming in at about half of what the 247 ion is.
That's correct.
This is a retention time of 0.92 minutes. Is that what that means? RT 0.92?
Yes.
So similar to what it was with yours when it was 0.91.
Yes, it's just one single look at that peak instead of the whole
peak. And yet in this one, you have the exact opposite of what you should get for a signature ratio. For a ratio of 132 to 247, you have the exact opposite of what you would expect to get in your signature for EDT.
Well, I wouldn't assess this for the ratios, and I did not assess this for the ratios. I would average across the whole peak, as I did with the positive control A, average across the whole peak in order to make the determination.
Okay, tell me what the difference is between the positive DSI mode and the negative DSI mode.
Well, it's simply flipping the electronics around. In the mode, you're looking at fragments that have a positive charge, and in the other mode, you're looking at fragments that have a negative charge to them.
All right. So, not that we have had enough of a lesson to understand how these machines work, but certainly they do require some interpretation in order to make a call or not make a call, right?
Yes, it does.
EDTA is biodegradable.
Not readily, no.
But it is eventually, right, if it's broken down?
Not significantly, no.
Well, you said you apparently are aware of studies about how it is the most ubiquitous chemical in the environment now, right? Man-made chemical.
That's right.
And there are many studies about how to deal with it in wastewater treatment, for instance, right, in the environment.
That's correct.
And they come up with methods to try to break it down to biodegrade it, right?
Harsh methods, yes.
Okay. Well, it, for instance, has been found to break down more quickly if the pH is raised.
Yes, that is correct.
So a more base or more I always say alkaline pH level will make the EDTA degrade faster than a neutral.
That's correct.
Okay, now you talked briefly about some kind of study that you did on the stability of EDTA based upon pulling out some random blood card that you still had from 33 months ago. Is that it?
Well, I didn't have them personally. Our DNA unit had a number of spot cards where they had put EDTA blood onto these cards, and they were stored at room temperature from May of 2004.
Okay, so you do recognize then that the whole question of whether just how stable EDTA is, whether it breaks down over time and could affect your ultimate opinion in this case.
If EDTA was known to break down, or if our studies found EDTA to break down, then that would be absolutely have an effect on my opinion, in my opinion.
Okay, what study have you seen that's ever tested an 11-year-old vial of blood to see how EDTA breaks down or doesn't break down?
I think the only study is the study that that we did for this case with
Oh, really?
with the actual blood itself.
Okay, and your report, by the way, is in front of you. What is that, 435, Exhibit 435? Is that still in front of you?
Yes, it is 435.
What is the date of your report?
February 26th.
I'm showing you Exhibit 444, which is 2 pages of the section of discovery that you gave me.
Yes.
Can you identify that?
Yes, this is an EDTA stability study that we conducted very late last week.
And it's put up on the Elmo so the court can see it. This consists of 2 pages, one of which is one typewritten paragraph, right?
Yeah, that's my brief summary
Okay.
of the results.
And the second page is a few handwritten notes from whoever did the study. Who did that?
Dr. Jason Brewer.
Same guy?
Yes,
The date of that study?
2/28/07.
So you did the so-called stability study 2 days after you actually filed your report.
Yes.
So if you had done this study and found out, oops, this EDTA isn't as stable as we thought it was, you may have to retract your report or amend it, right?
Well, again, well, yes.
And this is the sum. The first page of this exhibit 444, this one paragraph, is basically your study. That's all that's written that explains what your study is, right? Your EDTA stability study is this one paragraph.
No, it's that page and the other page you showed with Dr. Brewer's notes.
Handwritten notes.
Yes,
You're not going to publish this study, I assume, are you?
I never even considered it. I don't know.
Well, let's talk about it for a minute. What you did is you pulled out 10 spot cards that were 33 months old, stored in room temperature, right?
Yes,
And 4 of those 10 did not show EDTA-free acid form at all, right?
no, that's not correct.
Do I have it backwards? I'm sorry. 4 of the spot cards did not show the EDTA iron complex, right?
That's correct. 4 of the 10 showed an indication of it, but it didn't meet our criteria for calling it.
So you couldn't call it.
That's correct.
So in just 33 months at room temperature, some controlled environment you have, we see some degradation going on with the EDTA because 4 of them, you're not able to see the iron at all, are you?
Well, I disagree with your statement there that you see
You don't know what?
the grade.
You disagree with the degradation part?
I disagree with the degradation of EDTA. What you can see here is either the EDTA iron is becoming unbound potentially.
That's called
The EDTA.
degrading, right?
Well, it's dissociating is what it's called, not degrading. It's called dissociation back to the free acid form. So that's one potential explanation because you can clearly see that EDTA in every one of those spot cards, the free acid form. So either that is taking place and that could be environmentally occurring, or it has decreased to a level that we're not able to detect.
Okay.
We can't tell, though, looking at these results, which of these 2 scenarios are the actual answer.
All right. So one scenario is that it has decreased to the level you can't detect, right?
That's true, yeah.
And your study, if you want to call it that, doesn't discriminate for one or the other, right?
For the EDTA iron complex, yes.
And so all you know is that when you tested these 33-month-old spot cards that 4 of these 10 that you tested, you were not able to read or get a reaction detectable level of the iron, EDTA iron.
The iron complex, yes.
Okay. Did you test for a calcium complex in any of these?
No, as I indicated earlier, the amount of calcium typically in blood is 10 to 30 times lower than the amount of iron. So it made more sense to focus on the iron complex.
Okay. Now, your study is of 33-month-old blood on spot cards, right?
That's right.
And the spot cards are on paper.
Yes, they are.
And they're supposed to be a stable substrate, so to speak.
They're exposed to the environment, to air, so.
But there's not supposed to be anything on the paper that would cause degradation, for instance, or anything like that.
That's exactly right. They're sterile matrix that the blood is placed onto.
And presumably some sort of stable pH.
Yeah, the pH would really come from the environment
Okay.
that it's exposed to.
Okay, but you don't know how the blood vial in Mr. Avery's case was stored, right? For 11 years.
No, I don't. I don't know if it was stored. I'm going to make an assumption it was stored with the cap on, otherwise it would have leaked out. But other than that, I don't know if it was stored refrigerated or at room temperature.
By the way, when you can tell that the cap had been removed at some point, right?
Yeah,
That was obvious from your examination. You could tell someone took that cap off.
that's exactly right, yes.
And if there was less than what you would expect amount of blood in that vial, 10-millimeter vial, and it had only 5.5.
I wouldn't. Well, that's a two-part question. Yes, I did certainly recognize that the cap had been taken off. You can tell that it had been taken off. It was less than I thought it should be there. So is that your question?
Well, I guess you wouldn't necessarily, or would you know? I mean, is it normally filled when you see
No.
okay,
Typically,
normally more than half filled?
when you fill a blood tube, it's filled about 2/3 of the way to the 3/4 of the way up.
So you don't know whether there was blood taken out because you don't know what the original volume was.
Exactly, I don't.
But you do know the cap was removed.
Yes, I could tell.
So it was no longer in a vacuum state inside the tube.
That's correct.
And some sort of air and bacteria had been exposed to it by taking the top off and bringing it and putting it and bringing it back on.
Sure, some limited air that would just basically replace
Right.
the area that was left in that tube.
But you don't know anything about what conditions of heat or it was stored in for 11 years, do you?
No, I don't.
Or cold?
No, I don't.
Or the pH environment that it was stored, right? You would be guessing, but you don't know.
Well, the pH is going to be of the blood itself, so it's not stored in an environment of pH. That was implied that it's being put into something else that has a pH.
And the same thing as far as the storage of the swabs. Let me make one thing clear here. The swabs that you tested were the swabs, as far as you know, that were taken in November of 2005 from the vehicle, right?
Those were some of the swabs we tested, yes.
3.
There were 3 swabs, yes.
We'll get to controls later. If someone had used that blood vial to plant blood in the RAV4, then those swabs, as of November of 2005, were about 9 years old.
I'm sorry, I was confused on what you just asked.
I'm sorry. If someone used that blood vial, which was drawn in January of 1996, to plant blood in the RAV4, okay, then the swabs that were made from that blood would contain blood that was about 9 years old.
Yes, that's correct.
Okay. That had been stored under conditions that you don't know for the 9 years, right?
That's correct.
And then those swabs were taken and sent to various places. And again, you don't know how they were stored from November of 2005 until you received them in February of this year.
That's correct.
Before you tested the vial Q49, did you shake it up, mix it up?
Yes, I did.
You don't know whether or not for 9 years that blood was sitting the way it was. You don't know how that EDTA was reacting within the liquid, do you? Bad question. Let me rephrase it this way. You don't know whether over a 9-year period the EDTA would remain homogeneously distributed within that vial of blood, do you?
Well, yes, within a reasonable degree of scientific certainty, I would expect that it would be equally homogeneous throughout because it
Then why did you shake it up, sir?
just standard practice. I always do. Always shake a tube of blood when I get it.
And that way, you know it's going to be mixed evenly, right?
Correct.
You don't know whether that blood vial that sat for 9 years up until November 5th, you don't know whether the EDTA was homogeneously mixed in that liquid at the time, do you?
If I could clarify my answer, I think I do. And the reason I say that is because anytime something goes into solution, which blood is essentially water, and these are things that are dissolving into the blood, just like if you put instant coffee into hot water, you're going to stir it up, it's going to dissolve into the hot water. If you let it sit, the coffee doesn't start to recrystallize and sink to the bottom, and you have clear water and coffee. It's going to stay in solution and be distributed throughout that tube of blood.
But, sir, have you done this? Is your assumption, right?
Well, it's based on my education.
Have you done any tests or are you aware of any studies that would describe how EDTA would act after 9 years of just sitting in a tube?
No, I have not personally done anything like that.
And have you noticed that when blood sits for a long while, there's some sediment? It sort of will separate slightly into the plasma, or the red blood cells are heavier and tend to fall to the bottom.
Especially in a tube that doesn't have a preservative in it. That's true.
Okay, would the EDTA iron chellates, I think you called them, right?
Yes.
Would you have a higher or greater specific gravity such that they may, than the rest of the blood, such that they may sink to the bottom?
No, because again, these are still water soluble entities.
But sure, but they have
So
so they have bound the iron ones have combined with the iron molecule, right?
it has bound to the iron molecule. Yes.
And so, wouldn't you agree with me that specific gravity of that isotope or shallot would be different than, let's say, the free EDTA that's not bound with anything?
No.
Okay. In any event, you don't know if some police officer was intending to use that 9-year-old vial to plant blood. You don't know whether that officer would have shaken it up or not before doing that.
No, I don't.
And you don't know whether the portion that's poured out may have a lower concentration of EDTA than it would if it had been all mixed up, do you?
I don't believe that's a realistic scenario.
But you haven't tested it.
No, I have not.
And when this blood vial came in, you didn't do that kind of test before mixing it up.
Well, it would have been mixed just getting to our laboratory. Anytime it's shipped or moved from location
Sure.
A to B, it's mixing. So that would be irrelevant. If I tested it in my laboratory, it wouldn't answer your question.
Okay. You do know from the Cooper case, I believe, at least the EDTA on fabrics may migrate and distribute it in a different non-homogeneous manner, right?
I read that was the opinion of one of the experts in the Cooper case. I don't know that I share that opinion.
Well, didn't you say that that was, in fact, one of your concerns was that a drop of blood on fabric might expand and migrate in ways such that the EDTA levels might be different?
No, that wasn't what I testified to.
And you tested one from the swabs that were taken from the RAV4, they were not on spot cards, right?
No, they were not.
They were cotton, absorbative cotton, right?
Yes, they were cotton applicators like Q-tip type.
Okay, and a portion of it was cut off.
Yes.
You don't know whether or not the EDTA that might have been in that blood stain, once absorbed by the cotton, might have migrated in different concentration levels, do you?
Sorry, I need you to repeat that.
You don't know whether once that stain was swabbed with cotton and gets absorbed into the cotton, you don't know whether the EDTA, if there was any in the blood, might have migrated differently as it swabbed into the cotton, stronger in one place, weaker in another.
That would go against most principles in chemistry for that to happen.
Let me go back to the peaks for just a moment. You mentioned this, one of the spikes was a 293 ion. Do you recall that? I think you called it the parent.
It's the parent ion in mass spectrometry when you are running it in a positive electrospray ionization mode.
And how many other organic chemicals in the world also share that parentage?
Have a molecular weight of 292?
I think it was 293.
Well, the molecular weight is 292. It adds a proton, proton, onto it to increase the weight by 1. I don't know how many other chemicals in the world have a molecular weight of 292.
Do you know how many other organic chemicals in the world have a parent peak of 293, a base peak of 160, and also peaks of 132 and 247?
Just looking at the mass spectrum, I would think that there is probably no other peak, no other compound in the world that gives that same mass spectral profile.
And have you compared it to any library of other organic compound spectrum that you have in your lab?
Yes, that spectrum is very characteristic of what you would find in a library for EDTA. It's very characteristic for that you find in publication, Your Honor, that's previously presented for EDTA.
How many other organic chemical compounds would have spectrums that would be close to that?
I don't know. There's over 12 million chemicals, and there's no way that we can evaluate every single one.
Well, what's the machine's or instrument's tolerance for being able to detect, let's say, a 292 from a 293?
It's set up so that it's within one mass unit. Essentially, it can differentiate 293 from 292. It can differentiate 293.5 from 293.4.
Okay. By the way, did you ever do any, or did Mr. Brewer ever do any presumptive tests on these swabs to be sure what he was testing was the swabs from the RAV4? Did he ever do any presumptive tests to be sure he's testing blood?
No, we're not qualified to test for blood, for the presence of blood in the chemistry unit. That's done in our DNA serology unit.
Okay. You know what I mean when I say substrate.
Yes.
That's sort of like a surface that a swab, in this instance, would be taken from.
Yes.
And you don't know how the EDTA might have been reacting to different substrates within that vehicle, do you?
No, not really, no.
And there are different ones. One is a dashboard around the ignition, right?
Yes.
That's what you've been told.
Yeah.
You haven't actually seen the vehicle.
I have not seen the vehicle. I have seen pictures.
Okay. Another is like some sort of vinyl CD wallet case.
Yes.
And another is a metal surface.
Yes.
And you don't know how the EDTA may bind with any of those chemicals that are on those various surfaces.
Well, the metal surface wasn't bare metal. It had painted metal. It was painted metal, so it's not metal like what we have been talking about. Other than that, I wouldn't expect there to be a significant amount of binding.
But you don't know, for instance, even though it's paint, there may also be some sort of wax on top of it.
That's right.
or other, chemical cleaners that maybe leave a residue,
That's right.
such as Armor All, for instance.
Perhaps.
Okay, some of those substances, like for instance, Armor All has EDTA, right?
I don't know that to be true.
Does paint?
No, it does not.
So you did not, for instance, let me go back for a second. You weren't present when the November 2005 swabs were obtained, right?
No, I wasn't.
So you don't know how the lab technician swabbed those particular stains.
No, I wasn't present.
Neither were you present when the controls were taken in February of 2007.
No, I wasn't.
And you don't know, for instance, how close to the stain itself the controls were taken, whether they were ½ inch, 4 inches, what? You don't know.
No, I don't.
And by the way, each of those 3 stains had 2 controlled swabs sent to you, right?
Yes, they did.
But you only tested one.
That's right.
And you didn't ask the person who was going to send you the swabs to do an experiment where they actually poured some of the blood vial onto those same types of surfaces, that is, on the metal, on the CD case, and on the dashboard, and then swab those stains for testing, did you?
No, I would never recommend anything like that.
So if you had done that, for instance, then you would be able to say, hey, here's what this stain should look like if it had come from the blood vial, right?
I don't know if you can jump to that conclusion, quite honestly. Pouring it on and then saying, well, this is what it should look like if it came from that blood vial. It's making a lot of additional assumptions here. I don't think
Such as what?
that I would jump to the conclusion.
Such as time delay?
That is what's poured on as opposed to droplets being used to deliver it versus splattering it. That's probably the primary thing.
Why would that make a difference? If it's blood and it supposedly got EDTA in it, why would it matter how it was put on the surface?
It was simply your question you asked. I didn't agree with the final conclusion based on the question you asked.
Well, let me try rephrasing it. Probably wasn't that clear. If you wanted to be able to say that there's no way that those stains in the RAV4 could have come from the 11-year-old blood vial, you could have had someone create with a dropper or whatever, pipette, you could have had someone create stains deliberately with the blood vial, swabbed those and tested them, and then compared them to the swabs that were taken in November of 2005, right?
Objection, Your Honor. I believe we're really beyond the scope of an admissibility hearing now.
I'm going to sustain the objection.
You mentioned the auto sampler running in the middle of the night. It actually takes, if I understand your protocol, what the person does is take these samples, cotton swabs or whatever, put them in some sort of little test tube, and then add 200 microliters of a solution. Is that right?
Yes, it is.
And then that 200 microliters is allowed to sit and react for a period of time, right?
Yes.
And then the whole tubes are centrifuged and liquid is separated.
It's filtered essentially.
Okay. And the idea being that it's the liquid that you want because at that point you hope that it would have dissolved any EDTA that might be in solids.
But not just hope. Our validation demonstrates that it does. Our validation study demonstrates that it does dissolve any EDTA in the solid material.
Okay. And then, so there's approximately 200 microliters of liquid in these vials.
That's correct.
And the instrument only uses 5 microliters.
That's right.
So there's another 195 microliters of liquid that presumably would have the same result as the 5 that were taken out, right?
Approximately.
Do you have that liquid? Do you have that liquid to be retested?
No, we don't.
You destroy it?
Yes, we do.
So the defense has no opportunity to retest that solution that you have created to determine if it would get the same results as you do, right?
No, instead we left half of the sample that we were provided with. We used half for our analysis and left half for defense retesting using your own protocol, not ours,
Sure.
and your own controls, etc., to do their test.
But if we wanted to test your protocol and your method, and not just the protocol, but the accuracy of the technician, Mr. Brewer, who is doing this test, that liquid would tell us exactly what it should. If we tested it, it should match what you did if it was available, right?
Again, to me, it's a complex question. There's not a yes or no answer. If you wanted to test the work that was done by Dr. Brewer, you can look at the data that's in the packet and the controls. The controls let us evaluate whether or not the batch run operated as it was supposed to. It lets us assess whether or not the individual sample operated as it was supposed to. Now, if you want to test our method, then it's a fair, superior idea to take the method and put it into the hands of another scientist and let them run the samples, following the whole protocol, as opposed to them taking our final extract and putting it in other instruments.
But you don't keep the final extract.
No, we don't. We never do it in chemistry.
So, all right. What is your error rate in this protocol?
The error rate, I would say, is 0.
Have you done a study?
Well, yes,
Do you know what I mean by error rates?
I absolutely do.
Okay.
I teach on this topic. The error rate is something that you generally talk about when you're talking about your ability to distinguish a false positive from a false negative. And that's usually talking about a single analytical technique. So if you were going to just look at the HPLC method, you might be able to assess an error rate if you're just looking at the same time it takes for the compound to come out at the end of the column. Now, when you're running multiple techniques, it's what we call self-correcting. Self-correcting because, as I indicated earlier, you do not rely on a single analysis to make the call. You have to take all the pieces of the data that you have and make sure that it all supports the final answer. And if it doesn't, then you really shouldn't make that call.
Well, then are you saying that this kind of test, you can never attribute an error rate?
There's no numerical error rate that you can apply to something like that when it's this complex of multiple experiments being done and you're taking all of that data and applying it to a final answer.
So there may be some error rate, but we just don't know what it is. Can't be quantitated. Is that what you're saying?
No, maybe you could. One way that people assess error rates are looking at the results of proficiency tests. And as I indicated earlier, we did give ourselves a test, a blind test, and we had 10 samples.
10 samples.
10 samples that had either EDTA blood on them or did not, and we correctly identified them 100% of the time. So I would if you want to put a number on it, I would say we have 0% error.
All right. And you teach on this. So tell me, when you devise a method of trying to validate a test and trying to figure out what the false positive or false negative rate is 10 samples considered sufficient?
For that technique of determining the error rate, yes, it is.
When you were validating tests that can give you a known error rate, is 10 samples enough?
Generally, when we're talking about error rates, we're talking about, again, techniques that are not as specific as mass spectrometry. We're talking about non-specific techniques that just give you a sample positive negative result without a lot of data for the analyst to look at. So that is a technique that is a value, a numerical value that's another scientist know how good is that particular method. If I stand on those results alone and it doesn't have some expert looking over those data points in order to make that call. Now you're taking that and putting it into a completely different realm with LC-MS, MS techniques, and especially when you're talking about multiple techniques being used to get that final answer.
So if I understand your answer then, is that this LC-MS, MS technique just, you can't attribute an error rate to it?
I think you can by applying proficiency samples. That's probably the best way to
All right.
assess an error rate, and that's what we have done in the past when we're asked to determine an error rate on a complex method.
Okay. You said that EDTA,
Mr. Butin, can I ask about how much longer you think you have?
it's a while, half an hour at least.
We'll take a break at this time then, and resume at 2:45.
Okay.
Mr. Butin, you may resume.
Thank you, Judge. All right. You told us that EDTA is very commonly found, right, in the environment.
Yes, it is.
It's used in a lot of different, like household products, for instance,
Yes, it is.
detergents,
Yes.
some things like makeup, shampoo,
Yes.
some auto care products.
Yes, I'm sure there's some.
I'm going to show you exhibit. First of all, are you familiar with the National Institute of Health?
Yes, I am.
Okay, I'm going to show you an exhibit 445, which is something just in the public domain as sort of a list of products that contain EDTA. Would you just take a look at that for a minute?
Yes.
I mean, you don't have to memorize it or anything, but would you just consider a reliable, reasonably reliable database of products, general everyday care products that have EDTA as part of its composition?
Yes, it will be.
And so, just so it's clear for the record, that's like a 7-page document with a single page list of product, even by brand name like Zest and Suave and those sorts of things, right?
That's correct.
Now, do I understand that the FBI has not actually tested any of these products themselves to see whether they have EDTA or what levels they may be?
That's correct. We have not.
Okay, yet when you tested the controls which in your report are identified as K, what are they? K3, 4, 2, 3, 4 or something?
Yes, K2 through 4.
Okay, you found no EDTA in those controls, right?
That's correct.
Now, given the ubiquitous nature of EDTA in the environment, was that sort of an unexpected result?
No.
I'm going to go back to just a minute to this process where you cut off a piece of a swab Q-tip and put it into this little vial, okay?
Yes.
You do that with all of the control swabs too, right?
Yes, that's correct.
And then you put this 200 microliter solution in it.
That's correct.
If you had done that and then evaporated that solution down from 200 microliters to say 20 microliters, would that concentration of EDTA be greater
The relative
if there was any in it?
concentration would have been greater, yes.
Okay. And so if you wanted to test these controls, let's just talk about the controls for a minute, and evaporated that down from 200 microliters to 220, and then sent it through the auto sampler that takes 5 microliters of that. If there were EDTA in that background swab, you would be more likely to actually detect it with these tests, right?
Not necessarily, if I can explain.
Okay.
This particular instrument has been demonstrated to actually do the opposite of what you would expect. Generally, if we were talking about an instrument, if you concentrate a sample and shoot the sample into the instrument, you're going to get a better response. This particular instrument, our experience and others that use it have found that actually, if you concentrate it, you have a detrimental effect on the signal because of that matrix suppression that I talked about earlier that we evaluated as part of our validation study. So by actually diluting it, you dilute the matrix interference compounds or the things that might suppress the signal, and therefore you actually have a better signal for the analyte of interest.
So you might get a signal showing EDTA, but you might also get interference from other ions as well.
Not so much an interference as it is the signal is lower than what you expect it to be.
Okay, if you increase the solution from 200 microliters to 2,000 microliters, you're diluting it to the point where it may not show up at all, right?
Yeah, that's true.
So this level of 200 microliters, if you adjust it a little bit up or a little bit down, you can actually make it so that your test will not see EDTA even if it's there.
Well, if you take it to an extreme, yes.
Okay, now at the dilution level you chose, it may be that EDTA is in those controls, but it's just too small or too low for your test to pick it up.
That's true.
And the same would be true for the bloodstains next to the controls in the RAV4. There may be EDTA in them. It's just too low for you to detect with your dilution level.
And that's why we determine the detection limit. So we know what value that corresponds to, what we're no longer able to actually differentiate the presence or absence of EDTA.
But my point is, you cannot absolutely say that there is no EDTA in those bloodstains in the RAV4, right?
Wrong.
You can only say that you can't detect it at your level of detection, LOD. You are unable to detect it, right?
I'm able to say that the bloodstains that were collected from the RAV4 do not contain the amount of EDTA that would be expected if that source of EDTA came from that tube of blood collected from that.
Sir, that's not my question. Listen to my question.
I'm sorry.
My question is, you cannot tell us absolutely that there is no EDTA in those bloodstains. You can only tell us that there is no EDTA at a level that you can detect from your instrument.
That's a fair statement, yeah.
Okay, now, since you didn't provide an opinion about the level of or the quantity of EDTA in the test tube, not the test tube, let me rephrase that. As I read your report, what you're saying is your test detected some amount of EDTA in the blood vial, right?
Yes, it did.
But not an amount that you were able to quantitate and express an opinion on.
It's an amount that I did not quantitate.
Okay, and so you get a blood vial and it says EDTA on it. It does, right?
Yes, it does.
So one would expect if you test it, there will be some detectable amount of EDTA, right?
That's right, yes.
Although with 11 years of having gone by, we don't know whether this same level is started with or something that's less, right?
I think that I testified earlier. I think that you can get an estimate based on the analysis as to whether or not there was significant degradation.
But you don't know what you start off with. You don't know how much EDTA was in that tube to begin with, right?
Well, yeah, I do.
You are infuriating. You know a range?
I'm sorry. I know. I know based on that the manufacturers put into these EDTA tubes in order for the EDTA to function as they intend. Excuse me. Extend it to function. That the concentration when the tube is filled to the standard volumes that they put blood into these tubes, it ranges between 1,000 and 2,000 parts per million.
Okay, but now what you don't know, first of all, is what the original volume of blood, whether it filled that tube or not, right?
No, I don't know how much was originally in that tube.
Okay,
That's correct.
and you don't know, other than this range, you don't know the actual amount of EDTA that started off in that tube 11 years ago.
Well, it would be, in my opinion, that it would be between 1,000 and 2,000 parts per million.
Well, that's a pretty big range. My point is, you don't know the numbers, right? It's not like you just get.
Yeah, I did measure a number.
You don't know what you started with in 1996. You don't know what the number of EDTA was in that vial in 1996.
Not exactly, no.
Okay, thank you. And you mentioned that there's more EDTA in one of these blood vials than is needed to chelate or bind with metals like calcium and iron, right?
That's correct, yes.
But I can assume that varies sometimes depending on the person.
Depending on their diet, generally.
Okay,
We intake calcium, intake iron in our diet. And then through metabolic processes, we actually generate waste. There are those ions,
okay.
those metals, if I can clarify.
So what your opinion today basically is, there is EDTA at some detectable level in the blood vial first, right?
Yes,
And your opinion is that there is no detectable EDTA in the 3 stains from the RAV4 that you tested, right?
that's correct.
Let's take that last opinion that there's no detectable level of EDTA in the RAV4 stains, okay?
Okay.
That's something that you could have done if you had been asked back in November or December of 2004, right? I'm sorry, 2005, right?
Your Honor, I'm going to again interpose the objection. I think we're going way beyond the admissibility hearing.
No, it's where we're going directly to the whole question of the next motion, sequential testing or not.
Well, it does go to the next motion, but that's not the motion we're hearing at this time, so I'm going to sustain the objection. At this time, we're taking evidence on the state's request to have the witness testify as an expert. I'm going to sustain the objection.
Okay, your opinion that you prepared in the report does not in any way make a comparison to a quantitative level of EDTA from the blood vial to the bloodstains, does it?
We did not perform our quantitative analysis on this case.
Or comparative analysis of the blood vial to the stains?
I'm not sure I understand your question.
To get the results that you got on the bloodstains, you would not have needed the blood vial in your test, would you?
I think to interpret the data fully, we need the vial blood. But to get the results, you're right. We didn't need the blood vial.
Okay, and in fact, one of the requests that you got from the Milwaukee office when it described what was necessary and what kind of test it was, they asked you to conduct relative comparisons to swabs from the crime scene.
Objection, Your Honor. Relevancy for the purpose of this hearing.
Sustained.
All right. Is this a fair statement that, at best, your tests tell us whether or not there is any detectable EDTA in the bloodstains now, 16 months after they were found?
Yes, that's a fair statement, yes.
Your test does not tell us whether there was any detectable EDTA in the bloodstains when they first came to be in the Toyota RAV4 16 months earlier.
I'm sorry, but I disagree.
Well, would you agree that if there was EDTA in those bloodstains in November of 2005, then it matters not whether your test now, 16 months later, shows no EDTA?
Well, I disagree with that statement too.
And why is that?
If there was EDTA in the bloodstain when it was originally collected and it didn't show up today, to me that would suggest that there was some evidence switching, that it wasn't the same stain that we analyzed.
Okay, and that's based on your assumption of how fast or slow EDTA might change or degrade in the environment.
It's based on what's published and my own experiments that show that EDTA is quite stable in a blood stain, and in a tube of blood, I would add.
Well, I'm talking about the bloodstains for now, okay?
Yes.
In the little study that you made up from those 10 spot cards that were 33 months old,
Yes.
did you quantitate the amount of EDTA that were in those bloodstains?
No, sir. This was not validated as a quantitative procedure. So it was simply qualitative. Was it there or was it not there?
And you know of no study that has quantitated the bloodstain that is 11 years old versus one that's 33 months old.
A blood stain that's 11 years old?
Or a blood sample?
No, I don't.
Just one more question, I think. The matrix you mentioned for 4 experiments, something called matrix suppression.
Yes,
And what that does is tends to actually suppress an ion that is there, but you don't see it.
that's exactly what matrix suppression is. It suppresses the signal on the instrument, so you may miss something that's there. And we would, like I said, we did validate that.
And your validation there was that there could be as much as 33% suppression of what the actual amount should be.
That's correct. If the range of suppression was between 3% and 33% or 34%.
And that's not considered significant to you?
No.
All right. I have no further questions.
Mr. Gahn, any redirect?
Just one moment, Your Honor, please. No questions, Your Honor.
Very well. The witness is excused.
Thank you, Your Honor.
What do we want to do with the exhibit he has? Can we make a copy and file it later as...
What I have here, Your Honor, is the exact same copy. I will have this copied, and then we can mark it as an exhibit.
Very well.
Do you want to give it a number now or save one for it? But I will have it reproduced.
What's the next number?
446.
446? Oh, the full report will be 446.
And just so the record is clear, it's not a report, it's the lab sheets, data, those sorts of things.
I apologise. That's a good correction because I think the shorter document here is actually entitled a report. Alright, counsel, at this time the court will hear argument on the state's motion to admit the EDTA test results. Mr. Gahn, are you going to be arguing that for the state?
Yes, Your Honor. I'm going to rely upon that portion in the brief that we filed our motion to admit EDTA results and then permit expert testimony in the state's case in chief. And I will just refer to the court to pages 10 through 13, which I think certainly talks about the law and the status in Wisconsin. Basically, I think this court has to look at the analysis of the EDTA derived from the LC-MS testing procedures and determine if that is admissible. And the court has to look at 3 factors under our case law in Wisconsin. Is it relevant? I think clearly it's relevant to the facts in this case. Number 2, is the witness presenting the evidence? Is that person qualified as an expert to do so? I think clearly Dr. LEBEAU, through his testimony and through his CV, show that would be the case. And 3, is the evidence, would it assist the trier of fact in determining an issue of fact? And I don't think that the normal or the typical citizen of the community understands LC-MS technology and how it works and what EDTA is and its function and the analysis of that. And I think this certainly would clearly assist the jury in arriving at a decision in this case. And that's all I have.
Mr. Buting.
Actually, Mr. String is going to take this.
Sorry, Mr. Strang.
The way we divide things up, Your Honour, is that Mr. Buting does the hard work and I come in later. Walstad is the starting point, whether it ought to be or not. Much could be added to the discussion, but I won't. Wisconsin has not adopted the United States Supreme Court's approach to tender scientific or other expert evidence set out originally in Dorbert versus Merrill Dow Pharmaceuticals in 1993 and elaborated in cases after that. Wisconsin persists in the Walstad approach, and I agree in a general way with counsel that there are 3 factors the courts need consider under Walstad in deciding admissibility initially here. 1 is relevance. 2 is whether the tendered witness is an expert. And 3 is whether the evidence or the opinion would be helpful to a jury. Would the court prefer that I wear the...
Sure.
Mike, how is that? Does that work any better?
Yeah.
All right. The third criterion is, would the evidence or the opinion be helpful to a jury? And that really is where we found it here. the question of whether there was EDTA in the blood found in the Toyota. And the critical caveat here, whether there was EDTA in the blood in the Toyota in November of 2005 is relevant. That is, there is a material issue of fact here to be decided by the jury, which is, did the blood come freshly from Stephen Avery's finger or some other source on his body on or about October 31st, 2005, or did the blood get in the Toyota because put there by someone else, presumably from a vial that itself dated back to 1996? And we can, the vial contained EDTA, let's assume, for the purposes of argument, even setting aside the expert's opinion confirming that the vial contained EDTA. So that's a material question in this case, and evidence that made it more or less likely that a material proposition was true would be relevant here. So if this is evidence that there was no EDTA in that blood in late October or early November 2005, then it's relevant. Mr. LEBEAU's qualifications, particularly as an analytic chemist who can use a liquid chromatograph matched with a tandem mass spectrometer, is beyond serious dispute. We won't dispute that here for purposes of the admissibility determination, he's a good deal more qualified than the holders of bachelor's degrees from our state crime laboratory in Madison who have made their appearance in this trial. But the problem is whether this is helpful to a jury. And what this court is being asked to do, just so that no one else makes any mistake about it, Your Honour is being asked to join a select club. In fact, there's only one other member of the club, so far as anyone knows, and the founding member of the club is Judge Lance Ito from the Superior Court of Los Angeles County in the O.J. Simpson trial. And Your Honour, the state nominates to be the second member of this club, and that is, of judges or courts who have admitted evidence concerning EDTA analysis in dried bloodstains in a criminal trial, and the similarities between that which Judge Ito did and that which Your Honour is being asked to do actually continue. We now know, after testimony today, that the protocol for testing was prepared hurriedly, that it was prepared during the O.J. Simpson trial, which, of course, went a good deal longer even than this trial. I think the preliminary hearing in that case went a good deal longer than this trial, but it was a mid-trial creation of a protocol, mid-trial testing, and then, evidently, further mid-trial retesting and reconsideration of some of the earlier results. That, of course, is what we have here. As Mr. Buting has discussed before, and I think even offered the court, or at least read from an email between Mr. Kratz and the crime laboratory, non-quantitative EDTA testing of the bloodstains from the Toyota was under active consideration by the state in February of 2006. For strategic reasons, evidently, the state chose not to pursue that testing then. Now, beginning about the end of January 2007, the state decided to pursue such testing and inveigled the FBI into doing it, or prevailed upon the FBI chemical unit at the laboratory to assist the state in that manner. Those tests occurred sometime between February 1st, when I believe the actual swabs and control samples were received at the FBI laboratory. I may be off a day or two, but I'm very close there. And what is it? February 26th, that our report is dated, or Mr. LEBEAU's report is dated. And if I recall his testimony, the work on a protocol for conducting those tests began in January 2007. The protocol evidently was, according to his testimony, ready for an approval process by February 14th, 2007. We were at that point 9 days into trial. And that approval process evidently went very smoothly for Mr. LEBEAU because the protocol itself was issued and dated February 15th, 2007. So within 1 day, I gather, from his testimony and the date on Exhibit 434, approval was accomplished within the FBI bureaucracy for this protocol. The protocol was developed for no case but this. The protocol has been used in no case but this. The protocol is unrevised. The protocol has been validated, if at all, only internally in the FBI and, again, approved apparently in the course of 24 hours after submittal for approval. All of these things are similar to the evidence that Judge Ito admitted in the Simpson prosecution out in Los Angeles County. Now we have results that are non-quantitative and that express necessarily an opinion that no EDTA is detected in the swabs, the 3 swabs from the bloodstains, or in the control samples that were also submitted at the same time. Although Mr. LEBEAU ventures an opinion that he, therefore, can opine that no detectable EDTA was present back at the relevant time, October, early November 2005. He has to support that opinion, 1 degradation study, and apparently 1 degradation study only. Your Honour has seen the entirety of it, 2 pages, 1 of handwritten notes and 1 that consists of a short paragraph. And as I understand it, what Mr. LEBEAU did was went over to the DNA unit across the hall, or wherever it is figuratively in Quantico, said, "Let me have some old spot cards, which would be blood on a different medium than submitted here, on a pH neutral stable matrix of a spot card." And evidently, someone told him that the blood on these spot cards came from something from the EDTA purple top tube. We don't have much detail on how he satisfied himself of the EDTA origins or content of the spot cards. These things are about 33 months old. He tests the 10 of them and he finds EDTA in the free acid form in all 10 spot cards. Finds the iron chelate of EDTA in hardly more than half of them in 6 out of 10, and sort of dismisses that as insignificant to his conclusion that, boy, EDTA sure must be stable and must not degrade quickly in bloodstones. We don't know why he dismissed that so freely, other than that he seemed to take reassurance from the fact that he found the free acid form of EDTA in all 10 of these. And that's it. He hasn't been peer-reviewed by anybody, evidently not even within the FBI, so far as the record shows. Certainly hasn't been published. Certainly doesn't explain what differences in degradation there might be were a different matrix or medium to be used. For example, the cotton swab that was submitted here, as opposed to the blotter paper spot card there, which of course is specifically designed for stabilizing and holding blood, doesn't have any way to explain, or hasn't, so far as we can see, considered what environmental differences there may be that would have produced different degradation or could have, and has no way at all to extrapolate to the degradation he would expect in a 9 or 11-year-old sample of blood in any medium, whether in the vial, whether on the swab, whether on the substrates found in the Toyota. So he is not able here to give us any curve at all, because he's only got 1 point to plot on the graph, which is 33-month-old spot cards. We don't have anything that's less old. We don't have anything that's more old. We have nothing that would establish a rate of degradation in any environment, let alone in the relevant environment. So to suggest on that data set and with that level of scrutiny that this is helpful, that's an opinion that the EDTA was not detectable or present back in November of 2005 based on a failure to detect EDTA in the blood swabs in February 2007 really is rank speculation, or so close to rank speculation that it's simply not helpful to a jury. The opinion just isn't helpful. Now, you know, an analogy, if Your Honour were trying a slip and fall case in a commercial establishment, and the question, the material issue was what comparative negligence ought we assign to the plaintiff, and the defendant store owner wanted to call a palm reader and an astrologer. The palm reader would say, "I have examined the plaintiff's hand and he's the kind of person who is prone to accidents and he must have known that." The astrologer to say, "The plaintiff's zodiac for that month, his horoscopes for that month, says that he ought to be careful because unexpected things could happen. This would be relevant under the Wallstead standard, and a properly qualified horologist or astrologer, a properly qualified palm reader, one of many years' experience, certainly could be qualified as having specialised knowledge. But their opinions, I submit, would not be helpful to a jury, and even under Wallstead, wouldn't be admitted because unhelpful, even though the issue of comparative negligence and whether the plaintiff took adequate precautions is relevant and the witnesses are qualified. The examples are a reduction to the absurd, and I don't here stand before the courts and suggest that Mr. LEBEAU is the moral equivalent of a palm reader or an astrologer. I don't suggest it, but the example also is illustrative, I think, of how his opinion here, based on the hurried assembly of a protocol, the mockery of a degradation or stability study, the lack of outside validation in any of the work, and the effort to extrapolate without degradation data back from February of 2007 to November 5, or days before that, 2005, is simply not helpful to a jury. It would be possible here for the court to admit the opinion that in mid-February 2007, within the detection limits of the FBI lab, there was no detectable EDTA in the blood swabs. On that opinion alone, the state is on much more solid ground. But the opinion that, therefore, the blood in the Toyota did not come from the blood of Stephen Avery's vial, which is necessarily carries an opinion about what the EDTA level would have been in the swabs of the dried bloodstains at the relevant time, again, autumn 2005, that's not helpful to a jury because it's wholly unreliable, unsubstantiated, other than by the man who wrote the protocol, was one of the people who approved his own protocol, donated his blood for the test, supervised the testing, and assigned himself to the case. Now, let's not forget, in weighing all of this, that although good, Mr. LEBEAU clearly is not perfect. He didn't claim that he is, and if it were possible to bring Dr. William Cybers here from Florida, I would have a pretty good witness to tell the court that Mr. LEBEAU and his work is not perfect, neither are perfect. He was proven wrong there on an effort to extrapolate back 9 years in embalmed tissues the presence of a metabolite, a muscle paralytic drug, succinylcholine. As we showed, the Assistant Attorney General, Special Assistant Attorney General for the state of Florida, who prosecuted that case, later filed with the court a document warning that Mr. LEBEAU's results, and for that matter, National Medical Services results, Dr. Ballard's results, ought not be relied upon. So it is a select club that Your Honour is being asked to join. What's different, and I mean I'm foreshadowing the next argument, but this has a bearing now on this question. What is different and worse about this case and Simpson is that Your Honour is being asked to admit these mid-trial results and opinions extrapolated backward from the results without benefit of degradation data when one side, and one side only, as a practical matter, will have the ability to do any testing at all. And that's where this case really is different from Simpson. There is no reason to believe, and indeed, if my memory serves, both sides in Simpson participated in EDTA testing and had the opportunity to do that during the course of that trial. Not so in this. And there is no $14 million defence fund here that there was because O.J. Simpson was the 1 in a million criminal defendants who had the kind of money to put into his defence for experts, for lawyers, for Barry Sheck and Peter Neufeld, people from the Original Innocence Project at Benjamin Cardozo Law School, people who are well versed in chemistry and in forensic science. So acknowledging that it would be possible here to allow part of Dr. LEBEAU's opinion, that is, the opinion that no EDTA was detectable by the method they used in February 2007, I think the court would err and would allow evidence that is not helpful to the jury were it to allow Dr. LEBEAU to go further than that. And the fact that there will be no independent testing has a bearing on this Wallstead analysis because if for no other reason than because of this, The failure to detect EDTA in control samples here is highly, highly suspicious, given the ubiquitous presence of EDTA in the whole gamut of consumer products, from the soft drinks we drink, where EDTA is used to prevent a carcinogen from forming, benzene, to Armour All, used to clean cars and their interiors, to all sorts of personal care products, detergents, cleaning products. The failure to detect any EDTA in any of the controlled swabs is a bright red flag here. And we would start immediately with that if we had an opportunity to do independent testing, because it's just flat out counterintuitive. It just does not comport with common sense. I will venture a guess that the belief that the state would find EDTA in the dried blood stains and in controlled areas is what led the state tactically in February 2006 not to undertake this very testing, on which they have taken a chance now. Once it turns out there is a blood vial, that there was a source of whole blood that could have been planted here conceivably. And I don't know whether the answer for these control swabs would lie in just because there really was no EDTA detectable, or whether it would lie in the dilution that the FBI used, 200 microliters of inner reagent or fluid added to 5 microliters of the sample. I don't know. I'm not a chemist. We'll never know before this jury comes back with a verdict if the court admits Dr. LEBEAU's testimony. I ask the court not to go down that path, not to join Judge Ito's club, and not to admit opinions from Dr. LEBEAU that, although they sound impressive, coming from an FBI expert, in fact, offer no honest help to this jury.
Mr. Gahn.
Your Honor, the state is simply asking this court to apply the law in Wisconsin to the admissibility of expert testimony and scientific evidence in Wisconsin. We have given you a statement of the law. I'm sure the court is aware itself of the standard of Wisconsin for the admissibility of this type of evidence. I think Dr. LEBEAU clearly established to this court the wide use of the LC-MS technology, and that it is a technology that can test for chemicals. It doesn't make any difference what the chemical may be. He's testified how samples will come into the FBI and say, would you test this to see if there are any chemicals in it? And perhaps there would be a panel that they will find, or some item will come in and say, will you test this for a specific chemical, such as cyanide or something, or EDTA? All of that is possible to be done. It's done with very standard, well-recognized instruments in the scientific community, and that's exactly what he did. Samples were submitted to him to test for the presence of EDTA. He has the technology that is worldwide recognized, capable of doing that. And that's what he did. I think he explained well that this was a qualitative test, not a quantitative test. I note that the defense has talked a lot during this cross-examination about quantitating this. But how do you quantitate something that's not there? His test results on the bloodstains from the RAV4 and on the controls from the RAV4. There was nothing there. So this was a qualitative test under the umbrella of analytical chemistry and very valid in the scientific community. I think he established his background and experience in the area of degradation. They did their own degradation studies. He talks about so many other fields that are testing for EDTA. EDTA can be somewhat of a problem because it does stay around, binds to metals. And there's problems in the agricultural world, wildlife, fish, and game. I think he was clear. This isn't something that's not tested for. It is tested for and can be tested for. Everything that the defense has brought up, whether it be about the controls, the commercial products, the suspiciousness about the testing results, data sets produced, degradation rates, all that clearly goes, Your Honor, to weight of evidence that has nothing to do with admissibility of evidence. And I think a reading of the Peters case, where they did an analysis under the DNA testing, clearly shows the difference between admissibility and issues that are for the weight of evidence. So it asks this court simply we're not inviting you to join any clubs, Your Honor. We're just asking you to look at the law in Wisconsin and apply it to the testimony that you heard from Dr. LEBEAU. Thank you, sir.
Alright, well, the reference to Judge Ito's club is interesting. Actually, from my recollection of that case, I believe the evidence came in without objection, because both parties must have felt that they had something to gain by it. So to the extent there is a club, one way or another, I think I'm probably the only member. The historical reference to the O.J. Simpson case is interesting, but my obligation in this case is to apply the law as it is in Wisconsin and determine whether or not the offered evidence is admissible in this case. And I think it's helpful to briefly review the standards that have been historically applied in this jurisdiction and others, governing the admission of evidence. At one time, the prevailing standard in many parts of the country was what is known as the Fry test, which held that the trial court is to determine whether the expert evidence had gained general acceptance in a particular field to which it belongs. In this case, I think there is a serious question about that. Because of the lack of significant history of EDTA testing, the United States Supreme Court subsequently replaced the Fry test with the LEBEAU test, which relaxed the federal standard somewhat, but still required a trial court to assure that expert testimony is reliable. In Wisconsin, it's pretty well established that we have a standard that is more lenient than even the LEBEAU test. That is the standard that sets forth in section 907(02) of the statutes. The statutes provide that as a condition to the admissibility of expert testimony, the evidence is admissible if it is relevant, if the witness is qualified as an expert, and if the evidence will assist the trier of fact in determining an issue of fact. In this case, I don't believe there is a dispute between the parties on the first two issues. Unquestionably, the evidence relating to the question of whether or not the blood in the RAV4 was planted is relevant. Certainly it was a large part of the defence opening statement and cross-examination of the witnesses, and likewise the state is equally concerned to show the jury that the blood was not planted, but came directly from the defendant, so I think it's definitely relevant. Likewise, there's not a serious dispute that the witness in this case, Dr. LEBEAU, is qualified as an expert. He testified to his qualifications. He's got a master's degree, a doctorate degree, he's worked at the FBI lab for a number of years. In fact, he's the head of his section. There's no question that he is qualified as an expert. This issue boils down to whether the evidence will assist the trier of fact in determining an issue of fact, and I think some of the comments that have been included in Wisconsin Court of Appeals decision and the Supreme Court are worthwhile repeating here as a backdrop, if you will, to the standard the court is to apply. The Court of Appeals in the Riva case reported at 266 WIS 2D 696 noted as follows: the approach, that is the Wisconsin approach to allowing expert testimony, has served to reduce the gatekeeper role of the Wisconsin trial court when it comes to expert testimony. Reliability is not part of a trial court's function. Rather, reliability is an issue for the trier of fact, not the trial judge or the predicate for admissibility. The reliability of expert testimony is an issue for the trier of fact, not the circuit court as a predicate for admissibility. Instead, Wisconsin relies on the vehicle of cross-examination to test the reliability of an expert witness. So, in looking at some of the items of dispute, as Mr. Strang pointed out, in which I am certain will be part of the cross-examination of the witness in this case, there are points to be made with respect to the reliability of the testing method that was used in this case. However, the court cannot say that the evidence would not assist the trier of fact in determining an important issue. The witness testimony was, to a reasonable degree of scientific certainty, that the blood that was found in the RAV4 did not come from the blood vial in this case. The results are not quantitative. To be certain, the question of degradation is an issue which will no doubt be explored by the defence in its case. But for the court on its own at this point in the proceedings to make a determination, degradation has been demonstrated to the point that the evidence will not assist the trier of fact is simply further than the evidence presented today authorises the court to go. The witness testified he didn't believe that the difference in the results here could be explained in terms of degradation. And while the evidence may not be conclusive one way or another, the court is not in a position under the law which the court is expected to apply to make that determination today. So, in conclusion, I believe that the state has met its burden here to show that the evidence of the expert is admissible under the standards of section 90702, and the court will grant the state's motion to allow Dr. LEBEAU to testify in this case. Based on the court's decision on the state's motion, it is necessary to rule on the defence motion for a sequential and independent testing. I'm going to take a few minutes to retire to chambers and review my notes about this, and then I will come back and issue an oral decision on that motion as well.
Judge,
Yes.
just a point of clarification so the record is clear. The court is allowing Mr. LEBEAU then to give an opinion, two opinions sought by the state that no EDTA was in the swabs when he tested, and that his opinion is, therefore, the blood on the swabs could not have come from the tube of blood. Is that right?
I believe he's got opinions about the blood in the tube, as well as the blood in the vehicle. I'm allowing him to testify about both those items.
But the ultimate opinion, though, of saying that the blood on the swabs could not have come from the blood in the tube, is that being allowed?
Yes.
All right.
All right, Mr. Strang.
I'm sorry, Your Honour. Just two follow-ups. One, we neglected to move exhibits 438 through 446, which were the items the defence marked on Dr. LEBEAU's cross-examination.
Any objection?
No, Your Honor, and I believe that I failed to move in exhibits 433 to 437.
No objection there.
Very well. All exhibits marked today then are admitted into evidence.
Second, Your Honour, I would be remiss if I did not pose directly to Your Honour an argument that Wallstead ought to be overruled, and that in the end, Wisconsin courts ought to come in line with Daubert and adopt a similar test of admissibility of scientific or expert testimony. I make that argument now and suggest that, particularly on something this complex, with as little of the underlying criteria of reliability as there are at present, a court acting as gatekeeper with, in many ways, superior resources and perhaps background knowledge of scientific endeavours could not make a finding of reliability as a threshold matter to admissibility on the opinions that Dr. LEBEAU proposes to offer. In the extent that Wisconsin leaves that reliability determination to a jury of laypersons, I think that this rises to a due process denial. A criminal defendant has a right both to be tried and sentenced on reliable information. The due process roots of that go at least back to the United States Supreme Court in Williams v. New York, which I think is 1948. And I'm sorry, I don't have a citation because I'm relying on my memory of the case here. But to that, if the court correctly applied Wallstead, a point on which I respectfully disagree with the court, nonetheless, leaving the reliability here to a jury for this unreliable evidence that the state proposes to offer, I think results in trying Mr. Avery on unreliable information and rises to the level of the due process violation. So I ask the court, on those brief remarks, to reconsider its decision on the assumption that Wallstead would be overruled, that its time has passed, and that Wisconsin will come into line with the federal courts and the growing majority of state courts that rely either on Daubert or even still on the more restrictive Fry test.
All right. The court will note your objection for the record, given the fact that Wallstead, I believe, has been reaffirmed a number of times in reported court decisions. I'm going to deny the request to reconsider the court's decision, but I will note your objection for the record. At this time then, since the court has ruled that the EDTA expert evidence offered by the state is admissible, the court is required to rule on the defendant's motion for sequential independent testing and funding. The defendant filed that motion on February 25th in order to permit the defendant to conduct independent testing for the presence of EDTA in what has been referred to as the vial of blood from the Manitowoc County Clerk's office from the defendant's 1985 case, as well as the bloodstains allegedly belonging to the defendant which were found in the victim's RAV4 vehicle. The motion requests that the court grant the defendant permission to conduct testing sequential to the FBI testing. That would involve either declaring a mistrial in this case or continuing it for a period of several months in addition the defendant requests that this testing be conducted at public expense, because the defendant is indigent. There certainly is provision in the statutes for expert testing to be conducted by both parties, including the defendant. The relevant statute is section 97123(5). The question in this case is really not so much the right of the defendant to conduct testing, but rather the timing of the request to perform such testing, coming as it does in the middle of the trial. The parties do not cite the court to any directly relevant case law on this subject, and I don't believe there is any. I attempted to find relevant case law myself. I think the court's decision has to boil down, as it often does in these cases, as one of a fundamental fairness, that is, under the circumstances as they have developed to this point. Does fairness and a meaningful opportunity on the part of the defendant to present a defence require that the relief being requested by the defendant be granted? In order to evaluate all the circumstances in this case, under that standard, the court believes it is necessary first to review the relevant procedural history of this case. The court has to consider not just the inability of the defence to conduct sequential testing at this point in the trial, which I doubt that even the state would contest as a given. I would think it would be difficult for the defendant at this point to conduct that testing. But the court also has to consider the opportunities that the defendant had in the course of these proceedings to conduct such testing, had the defence desired to do so. In that regard, I would go back first to July 10th of last year, which was the day the court issued an order requiring notification of any extrinsic planting evidence to be provided by the defendant, at least 30 days prior to the start of the trial. Approximately 10 days after that, on July 20th of 2006, that represents the date which the state asserted, and has on a number of occasions, was the latest date by which the defence knew of the existence of the container in the Clerk of Court's office, which represented that it contained Stephen Avery's whole blood sample, according to the defendant's original motion for access. As the defence noted in its argument, that's not the equivalent of knowing necessarily that the blood vial was there, because the blood vial hadn't been examined at that point. But the defendant has not disputed the state's assertion that the knowledge of at least the existence of the box representing that it contained the defendant's sample would have been known to the defendant by July 20th of last year. On October 27th of last year, the court issued a scheduling order, setting both a discovery deadline and a deadline for the state to name expert witnesses to December 15th of 2006. On December 6th of 2006, which was 9 days before the discovery deadline, the defendant filed a motion for order allowing access to prior court file, which sought the opening of the container purporting to contain the defendant's blood in the Manitowoc County Clerk of Court's office. On December 14th, the attorneys for both sides met jointly to examine the vial and found that it appeared to contain whole blood and represented on its label that it was the blood of the defendant. On January 4th, the state filed a motion to exclude the blood vial evidence, or an alternative, adjourn the trial in order to permit the state to analyse the blood sample. A hearing was held on that date. 5 days later, on January the 9th, the court denied the state's motion for a continuance in order to analyse the vial of blood. On January 12th of 2007, which was not quite but close to 30 days before scheduled start of the trial, the defendant did file a statement on planting blood describing the basis for seeking introduction of the blood vial evidence in this case. On January 16th, the state filed a reply opposing admission of the blood vial evidence. On January 19th, the state asked to be relieved of its obligation to disclose expert witnesses with regard to the blood vial evidence. The state did not oppose the request and the court granted it on record. On January 30th, the court granted the defence request to allow the blood vial evidence in, subject to limitations. Taking into consideration that part of the procedural history in this case, the court comes to a few conclusions. First of all, the court finds that the defendant in this case did timely comply with notice requirements that were set by the court. The statement on planted blood that was filed on January 12th was slightly less than 30 days before the start of the trial required by the court's order, but I believe that at some point after December, the court allowed that filing by date. The history also shows that the defendant had knowledge of at least the suspected existence of blood vial long before the state did. that is, sometime on or before July 20th of 2006. The defendant indicates at page 17 of his brief that counsel for both sides did not know of the contents of the box until they opened it together on December 14th. And while that technically may be true, given the label on the box, which was attached to an exhibit to the defendant's motion and the extensive information about the box in the defendant's December 6 motion, the court concludes certainly that the defence had much greater reason to suspect the existence of the blood vial well before December 14th, and in fact virtually immediately made it in public statements an important part of the defence case. The court also concludes that if the defendant had felt the testing of the blood was important, the defendant had adequate opportunity in which to arrange for such testing. The defendant could have sought release of the blood vial much earlier and requested permission to test it himself under section 971235. In the alternative, if the defendant did not want to risk spending resources on a test which could possibly produce inconclusive or unfavourable results, the defendant could have disclosed the existence of the blood evidence earlier, asked the court to set a deadline for the state to conduct any testing that it wished to conduct, and still allow the defence adequate time to make its own decision as to whether or not it wanted to independently test the blood vial, all of which could been accomplished well before the start of trial. In this case, the court believes the defence decision not to pursue the identification of the blood vial until very close to the discovery deadline was a decision that the defence was entitled to make. That is, I find that it was a reasonable decision on the part of the defence counsel. There certainly could have been a number of reasons for making that decision. While there are procedures for testing EDTA, as Mr. Button informed the court on January 4th motion hearing, there are no universal standardised protocols or universally accepted quantitative standards, and it would have been entirely possible that the result of any testing conducted by the defence could have been inconclusive. In addition, the testing results could have been inculpatory rather than exculpatory. Finally, by waiting until shortly before the time it was permitted to do so, the defence may have left the state with less time to prepare to meet the evidence and specifically with not enough time in which to conduct the state's own test. It certainly appeared, based on the original state request to adjourn the trial, that may have well been the case here. However, the fact that the decision as to the timing of the motion seeking access to the blood vial was within the deadline set by the court and was reasonable, that does not mean that the defendant is allowed to second-guess the strategy at this point and be entitled to a mistrial or lengthy continuation of the trial in this case. The court believes that it would have been highly foreseeable that, once made aware of the blood vial evidence, the state would want to test the blood in order to refute any planting defence and would likely make every effort to do so. On that point, I think it's worthwhile to go back to the transcript of the hearing on January 4th, that is, the hearing on the state's request to adjourn the trial in this case, and repeat some of the statements that were made at that time. Defence counsel informed the court at that time that it would oppose a continuance of the trial date unless the defendant was released on bail, including among the statements from the record of that hearing are the following from the defence counsel. And if that is, Mr. Avery is to remain in custody, we will and do oppose adjournment of the trial. We wanted to go forward on February 5th. If he is to remain in custody, that was from page 18 of the transcript. On page 19, defence counsel argued, but if the state wants to test and if Mr. Avery is to remain in custody, the trial ought to go forward while the testing process is going forward. At page 20, defence counsel argued, we don't pursue testing ourselves. We don't know that we will. We aren't asking to, but we understand why the state wants to pursue that testing. Going on to page 20, we may well oppose in the end the admissibility, the relevance of those test results, but that again is something the court would address with the benefit of knowledge of the test results, presumably, and a chance to look at the type of testing that was done, the protocols, and what the case law may have to say about the admissibility of similar tests. Of course, that all comes to pass, but the point is that the defence was aware that at the time that the state was going to pursue testing, the defence didn't oppose the testing from the state, as long as an adjournment was not granted, and even at that point in the proceedings, the defendant was not interested in pursuing independent testing. Of course, that all came to pass, but the point is the defence was aware at that time that the state was going to pursue testing, The defence didn't oppose testing from the state, as long as the adjournment was not granted, and even at that point in the proceedings the defendant was not interested in pursuing independent testing. Based on that history, the court concludes in this case that a defence motion for sequential independent testing and funding must be denied. The reasons are as follows. First of all, the court concludes that the defendant had adequate time in this case to pursue testing if he wished to do so. The defence was aware of the likely existence of the blood vial many months ago. The defendant had an adequate opportunity, after the discovery of the suspected existence of the blood vial, to pursue testing. As pointed out by the defendant, the state could have pursued testing of at least the blood evidence in the vehicle earlier as well, but the importance of such testing did not become evident until the defendant disclosed that it was preserved blood in the Manitowoc County Clerk's of Court's office. That was specifically the alleged origin of the planting evidence. There could have been other arguments available to the defendants. For example, we have heard testimony there was traces of the defendant's blood found in his trailer. It could have been argued that somehow the state got a hold of that blood or blood from somewhere else that may not have been preserved, that was planted in the RAV4 vehicle. If the blood that was alleged to have been planted was not preserved blood, the significance of the lack of EDTA would not necessarily have been terribly prohibitive. Both parties acknowledge that at this stage in the development of EDTA testing, there are not many generally accepted scientific methods for either testing EDTA or interpreting the results. From all the court has been able to learn at this point, that appears to be due more to the fact that there is not much of a demand for it than anything else. The court has not heard any evidence to suggest that it is more difficult to test EDTA than a variety of other chemical substances, especially under the standards for admission of expert evidence in the state of Wisconsin. Had either party decided they wanted to pursue testing earlier, they could have done so with the knowledge that the test results, as long as conducted by a competent lab, probably would have been admissible. The court does not find, in this case, that the FBI is the only lab in the country or is somehow uniquely qualified to perform this type of testing. As we heard earlier today, I think the last time it was conducted by the FBI was at the time of the O.J. Simpson trial. And referring again to the January 4th transcript, Mr. Button pointed out to the court at this time that their meaning the FBI's expert was called at the O.J. trial actually used by the defence in the O.J. case and was very helpful to the defence and ultimately very embarrassing to the FBI, who was part of a whistleblower allegations in the very lengthy investigation that the FBI did of misconduct or negligence or sloppy practices in their lab. So that's the role of the FBI in the O.J. Simpson case didn't exactly establish the FBI as the sole lab in the country that could reasonably test the presence of EDTA. Now, there is a case that was cited by the defendant in the brief that the court does agree is worth examining here. It may be closest case at least that somehow resembles the facts in this case. That was the case of the United States versus Kelly, where an appeals court reversed a conviction because the trial court did not allow for 1 month of continuance of a trial in order to allow the sequential testing as requested by the defendant. I'm going to quote from that case briefly, setting forth the facts and the ruling of the court. In June 1968, the seized drugs, and it was a drugs case, were sent to Washington for tests, including a neutron activation test which tended to show that the drugs all came from the same original batch. The government did not inform the defendants of this test. They, the defendants, only became aware of it at the trial, after the testimony of the prosecutor's first witness, when the government produced its exhibits. The appellants also contended that the government had a positive duty to disclose the results or at least the fact that they had taken them. This is so especially in light of the fact that the government had opposed discovery on the grounds that the request was not particular enough, and now the government alone had knowledge of the particular test it had taken. The course of the government smacks too much of a trial ambush in violation of the spirit of the rules. A new trial is required with a fair opportunity for the defence to run its own neutron activation test of the material to determine the atomic similarity or dissimilarity of the trace elements of the samples. The court believes there are at least a couple of significant differences between the facts in the Kelly and the facts here. First of all, the state has disclosed its test results immediately upon receipt. To the defence, the state did not have those test results available until after the trial in this case started. The court concludes that the state acted promptly after learning of the existence of the blood vial to seek to have the test of the blood conducted. The primary reason for the receipt of the results during the trial, as opposed earlier, is because the state did not learn of the existence of the blood vial until months after it was believed to exist by the defence. The court also notes that the defence, as I said earlier, would have conducted testing of its own, but did not do so, and as of January 4th of this year, still informed the court on the record it had no plans to do so. The court finally concludes that the remedies suggested by the defence in this case to allow sequential testing are inadequate. As I suggested earlier, had this matter come up well ahead of the trial, so that the results would have been in before the trial, I may well have ruled differently. I most likely would have allowed the defence to pursue sequential testing. But at this date, the remedies suggested are, first, a continuation of the trial for an unspecified period of months, and that simply is not practical. I think actually both parties in their briefs probably recognise that. First of all, it would be very difficult to prevent the jurors from being exposed to publicity about the case in the meantime. And even more significant than that, we have heard a great deal of testimony. We're beginning week 4 of the trial. I'm not sure how the jurors could be expected to have a meaningful recollection of the testimony that's been introduced, the evidence that's been received, and use that information to come to a verdict some unspecified period of months from now. Likewise, the court believes that there are simply no grounds in this case to declare a mistrial. The primary reason that the defence has not conducted EDTA testing earlier is because the defence chose not to pursue it when there would have been time to do so. The defence has made the alleged planting of blood a vital part of its case. As the defence counsel pointed out at the January 4th hearing, he, Mr. Avery, has been saying from the beginning to anybody with a microphone and TV camera initially as early as November 2005 that if his blood was in the Toyota, somebody planted it. So there hasn't been any secret about his defence and his view of the fact. If testing of the blood was determined by the defence to be vitally necessary to the planting defence, which was known from the very beginning, it should have been pursued far earlier than it has been. The bottom line in this case is that both parties had an opportunity in this case to pursue testing. The court believes that because of its earlier knowledge of the existence of the blood vial, the state had the defence had a slightly earlier opportunity, at least than the state, but did not pursue the testing. And for that reason, a continuation of a trial at this point is not warranted. Because of the court's decision denying the motion, it's not necessary for the court to act on the public funding request from the defence in this case. However, I feel compelled to make a few comments about that request, should it become relevant at some point. First of all, if a defendant finds himself in the position of Mr. Avery, that is, let's say the defendant was determined to be indigent, I believe the proper course to follow was set forth by the Court of Appeals in the case Dresser v Racine County Circuit Court, a 1991 Court of Appeals case. And the court there essentially, when a private counsel requested funding for the testing on the basis that the defendant was unable to comply with the terms of their retainer agreement and financially unable to either continue to pay the attorney or pay for the testing, ruled that the defendant should contact the public defender's office. There's a provision in the public defender's rules to allow not only for testing, but also to appoint acting counsel even in the middle of a case, and be paid for by the public defender if the defendant is unable to continue to comply with the terms of any retainer agreement. The other point I will note relates to the affidavit which was filed with the motion in this case. I did take some time to read that, and while I don't have the entire retainer agreement in front of me, the affidavit notes that the lump sum payment that was paid by the defendant to defence counsel was accepted as a minimum earned and maximum fee. That is, the fee was going to be the amount for representation in the trial, regardless of the amount of hours earned. Also significant in the court's mind is paragraph 7, in which the defence counsel indicates my firm's retainer agreement with Mr. Avery requires the firm to pay expenses including expert witnesses and any other necessary litigation expenses after the amount in our trust account is exhausted. Now, as I read that, the logical reading to me would be that the retainer agreement may well obligate defence counsel to pay for testing expenses that the defendant's status at this time as being indigent or not is not terribly irrelevant, because there is a contractual agreement which has already been fulfilled by the defendant. which requires defence counsel to pay for testing or expert witnesses. As I say, my ruling doesn't require me to rule on that, so I'm not going to. I only offer that as my observations. In any event, the court is going to deny the defendant's motion for sequential independent testing and funding. I will direct the state to prepare the order, both on that motion and the court's earlier ruling today. I will see the parties tomorrow, and the jury will back in here to begin testimony. Anything else before we adjourn today?
Do you want to meet briefly in chambers?
That sounds fine. We'll see everybody in chambers in a few minutes.